look at the question which was being referred at paragraph 58 of NN Global. And then, my lords, I had shown your lordships some portions of the Stamp Act, various provisions of the Stamp Act have been shown to my lords, and some judgments under the Stamp Act to show, my lord, that it's the instrument and not the document which is the subject matter of the stamp duty, and that it is really a fiscal matter. And, my lord, the existence and validity of the transaction or the agreement is not put in doubt if a document or instrument is not stamped. And ultimately, my lord, I had also submitted that in view of the interpretation that I was seeking to, my lord, advance, there will really be no revenue loss, because it is the arbitrator who will protect the interest of the revenue as he can, my lord, under 33 and 35.
Have you looked up the decisions under the 1940 Act?
Yes, my lord. I'll come to that, my lord. There is only one judgment which talks of stamp duty. There's a 1940 Act. 21 Calcutta. I'll come to that, my lord, in a moment. There is only one judgment. There is no real case of stamping or stamping. Lordship knows under the 1940 Act, there are various chapters. There is Chapter 2 arbitration without intervention of court.
That's right.
Then Chapter 3 arbitration. Chapter 2 is two, my lord. Then 3 with intervention of court. 4 arbitration in a suit. So, my lord, that regime is slightly different. I'll come to, my lord, that at the appropriate stage. My lord, so your lordships had a look at the Stamp Act, and, my lord, today I wanted to place, my lord, the relevant provisions of the Arbitration and Conciliation Act. Yesterday, your lordships had a look at some of the sections. Section 2, subsection 3, your lordships had a look at 5, 7, 8, and 11. My lord, these are sections that your lordships have already seen yesterday. I'm not going to repeat, my lord, on those 4, 5 sections. 2, 3 is on arbitrability. Section, my lord, 5 is non-intervention, non-obstante clause. 7 is the arbitration agreement. 8 is stay of proceedings, my lord, now reference to arbitration in a suit. 11 is appointment of arbitrator, which your lordships have seen. 11.6a, 11.6b, 11.13, my lord, which says you have to dispose of it within a very short time. So those provisions your lordships have seen. So, my lord, I pick it up from section 16, which according to me, my lord, is critical in deciding the reference, because, my lord, 11 cannot be seen in isolation. It has to be read along with 5 and in particular, my lord, 16. And I would respectfully submit, my lord, now after the 2015 amendment, 16 is to be given its full play. 16 must be given full play, my lord. It was curtailed in SBP. That SBP judgment has been legislatively overruled. 16 has to be given full play. Your lordships will first see 16. Then, my lord, the model law on 16, just by way of contrast, and then 2 paragraphs of Justice Thakkar on section 16.
Yeah.
And that is the thread which has been picked up, my lord, in the NN Global matter in the 3 Jan. Let's get out that 21.
Yeah.
Get that. My lord, may I just read section 16, because it is very, very critical to the argument.
Yeah.
Of the scope of the narrow scope of section 11 now. 16 says competence of arbitral tribunal to rule on its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of the arbitration agreement. So existence is covered, validity is covered, and it is an inclusive thing. So other aspects are also covered of jurisdiction, which may not be necessarily only existence or validity. So the word is including. And for that purpose, an arbitration agreement which forms part of a contract shall be treated as an agreement independent of other terms. Now, this is the principle of separability and competence. And B, a decision by the arbitral tribunal that contract is null and void shall not entail ipso jure the invalidity of arbitration clause. Well, the 16.
Banerjee, is it a coordinate jurisdiction really? Because section 16 starts with arbitral tribunal may. Does it exclude 11.6?
Well, Lord, it does not exclude 11.6. but there is the overlap, my lord.
Then what is your argument? That as a matter of prudence and practice, 11.6 court should avoid looking at this
My lord,
particular point.
there is some overlap between 11.6 and 16. The overlap is only qua the word existence. That's the first point, my lord. 11.6a only talks of existence. 16 also talks of existence. There, my lord, there is a judgment of your lordships in Praveen Electricals, which I will come to, Justice Nariman's judgment, which says that even qua existence, the 11.6a court will only make a prima facie determination and refer the matter even of existence to the arbitral tribunal. So, my lord, the overlap is very minor, and even where there is an overlap, it is as per the jurisprudence of this court, my lord, even existence prima facie is to be.
So 11.6a is examination of existence.
That's all.
So what kind of an examination you are expecting under the 11.6a?
My lord, there is that Praveen Electrical judgment, my lord, a prima facie examination.
We will have to understand what is the scope of examination.
Yes, absolutely.
Mr. Banerjee, we are 5 of us here,
Yes, my lord.
so not necessarily we are bound by
Not at all, my lord.
any
Not-
other.
Not at all, my lord. But I will show, my lord, the legislative history of 11.6 to show what was the intention of bringing in that provision. Certainly, your lordships can say, no, I want to, in 11.6, I want to finally determine, say, existence. It may be, my lord, your lordship.
Because the scheme of Stamp Act is not finally determined. Scheme of Stamp Act is all for the document, impound it, send it for valuation and 10 times penalty.
My lord,
So
there,
this is also a kind of administrative measure, quasi-administrative measure through the
my
judicial
lord,
forum.
there also, my lord, moment we come to, my lord, the question of
Because
judicial and
when we are-
administrative, my lord, we get into a little bit of a
1
problem.
minute, 11.6 court is looking at whether an arbitration agreement is there or not.
Yes,
That is the only scope.
right.
Now the document it's looking at becomes inadmissible, presumably inadmissible in evidence because of non-stamping.
My lord,
Because the
there I would-
requirement of stamping is not being questioned. At what stage we
My
look
lord,
at that?
The question there is, your lordships, there is one intermediate step, if I can, my lord, put it.
Just wait.
There is an intermediate step.
The meaning of inadmissibility we'll have to interpret.
Yes, my lord, before one gets to inadmissibility, so there is, my lord, let us play this out. There is a document which has come to me. I am a section 11.6 judge. I have to decide whether an agreement exists or not. Now, my lord, in the process of this decision, I have to look at this document,
Yes.
right? Now, my lord,
If it is not an admissible document,
now, my
then
lord,
whether we can
just
look at it or
if
not.
we pause here for a moment. Now, my lord, to decide on whether this is admissible or not, I have to examine whether or not this document requires to be stamped. This is what is being put to me, my lord.
Yes.
My lord, I am submitting that scope of inquiry or scope of examination is excluded. My lord, the word examination is used in two sections. 11.6 also uses the word examine.
No, 1 minute. If an argument is advanced that an arbitration agreement does not require stamping, then possibly it becomes examination. But if the view is that the arbitration agreement requires stamping,
May not, my
and
lord.
on the face of it,
There may
we see
be,
it's
I'll
not-
give an example, my lord. There may be an arbitration agreement in a document which may be otherwise exempt under the Stamp Act. So, my lord, the very
As,
fact,
for example,
my lord, certain government documents, they are exempted.
the
I'm giving-
government need not pay stamp
Yes,
duty.
so, my lord, the very fact of examination of a document, because then your lordships will have to decide number of things. Not only whether stamp duty is to be paid, number two, who is to possibly pay the stamp duty? Three, how much will be the stamp duty? For instance, in this case, this present case, my lord, there is a dispute. One party says the other party should pay, the other party says one party should pay. There is a dispute as to quantum. This court said pay 8 lakhs. My learned friend possibly correctly says it is not such a document which falls under X entry or Y entry. I will only get away with paying 500 rupees or whatever. So, my lord, the question is not to reach the stage of admissibility. You have to examine a document, and that examination is for the purpose of establishing whether or not it is to be stamped or not. My lord, whether that examination is to be left to the 11-6 judge or that examination is to be made by the arbitrator. Nobody is running away from the examination.
Mr. Banerjee,
Yes.
looking at the two stage that you are trying to point out, can we say that decision will have to be taken on shortfall or non-payment of stamp duty, but that is a deferred decision, and at the stage of 11-6, you don't have to take
You
that
don't-
decision.
Correct.
You defer it and relegate to competence of the arbitrator, whatever the.
I am
those
obliged.
principles
That
are.
is exactly my submission. And plus, to add to that, my lord, under 33 and 35, the arbitrator is an authority who is entitled to do that. It is not that one is running away. You know, 33 says either appointed by law, maybe 11-6, or even by consent. So even supposing the matter had not come before an 11-6 judge, supposing we had directly referred it to the arbitrator, he would have to have a look at it under 33 and 35. And he would deal with the problem. He would be in a much better position, my lord, practically to deal with the problem also. He would take it.
Just wanted to put to you, you look at the scheme of section 11,
Section 11,
section 16,
16,
and also 8.
also
You
it.
can have 4 actually sort of contingencies which can possibly.
There are various.
One is an application is filed in the section 11.
11, my lord.
There is no contest.
No contest,
Actually, there is no contest.
right?
The matter is referred to the arbitrator. Before the arbitrator, a question is raised relating to the very existence of the agreement.
Right.
We'll come back to it as to
Yes.
whether it can be raised, number one. The second is 11. It is disputed by the party, but the court finds there is an agreement and refers to it. In that scenario, whether under section 16, whether it can be raised.
Second situation.
Second. The third scenario is under section 8, where he raises and the court says prima facie a valid agreement and therefore refers it. Now, whether there he can raise about the existence of the arbitration agreement. The fourth category is where without any application to section 11,
Nothing.
whether any dispute, the parties
Agree.
participate in the appointment of the arbitrator. Now, that is a case where neither 11 nor 8 party agrees and the arbitrator is appointed. Now, if you come to section 16(2), if you read section 16(1) to begin with once again for the purpose of clarity.
16(1), my lord,
Yes.
is that the arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity.
That's right. Now you read subsection 2.
2 is a plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, party shall not be precluded from raising such a plea merely because he has appointed or participated in appointment. So merely
Therefore, even without recourse to section 11, there may be cases where parties the claims are referred to the arbitrator, they acquiesce in it, they participate in it. That will not stand in the way of the person participating, provided it's before laying his defense, raising the contention about the jurisdiction. You will notice one
Jurisdiction.
aspect.
jurisdiction.
In subsection 2
It is
is
jurisdiction.
referred to as jurisdiction.
Jurisdiction.
Now, in subsection 1, it says jurisdiction including
Existence and
the
validity.
existence or validity of.
It's a wider power.
So whether existence is the same as jurisdiction.
Existence is my lord, I would put it in concentric circles. Existence is the narrowest. Validity.
If you have parties, therefore the upshot is in these 4 categories which you have outlined. In a case, the first case where without 11(8), a party participates in the agreement,
No problem, my lord.
then can he come and say, not jurisdiction, but the existence of the agreement can,
Yes, sir.
can he
Can.
challenge it?
He can.
Which
He
is-
can because
which
of
is the
16.
judgment- Which is a judgment which lays down that.
My lord, 16.1 says so, my lord, straight away. And my lord, Praveen Electrical says so. Praveen Electrical.
Section 16(1).
16.1, my lord, you are ruling on your jurisdiction, including questions of existence or validity.
That's right. Therefore,
What if,
what the question is whether the plea relating to the existence,
Existence, my lord, is specifically there in 16.1.
we know that. We are saying that whether existence of the agreement is a matter which goes to the jurisdiction of the arbitrator. You say that it is.
It does, its section says so, my lord.
Including is actually
Including.
the word including.
Including.
It means it's a part of jurisdiction.
Correct.
Correct. Now, then what happens if he participates in the section 11?
My lord, I
As
have
an
done a
example.
number of cases like that. You say without prejudice, I appoint Justice so and so as my arbitrator, and at the beginning you say there is no concluded contract,
Okay.
so there is no agreement. Please
These
decide.
are all covered by authority.
All covered. So that is, my lord, situation one. More problematic, my lord, is situation which my lord put to me. Supposing, my lord, I say there is no agreement. I refuse to participate in the appointment of arbitrator. The other side compels me to, the other side is compelled to take the assistance of section 11 to have an arbitrator appointed. In that proceeding, my lord, I say that there is no concluded agreement. It is forged, it is fabricated, there is no concluded agreement. What happens then? Because, my lord, 11.6 uses the word existence. My lord, this is far beyond stamping, my lord. We are on a very narrow. My lord, if I say there is no agreement, so what is the 11.6 court supposed to do in such a situation? My lord, that specific case is there in Praveen Electricals in your lordship's, my lord, compilation I have put it.
So even if he disputes and still 11 is allowed.
My lord, it is very interesting. There what the court says, my lord, and it takes recourse to Vidya Drolia and it takes recourse to the legislative history is, supposing you find that really there is no agreement, then you take a final view on that and throw it out. There is no agreement, there is no concluded contract. If you feel that it requires, if you, the 11 court feels that it requires a deeper consideration, that it is not clear, one party is saying it is forged, the other party is saying it is not forged, then you leave it to the tribunal. So that is how this court, my lord, has both in Vidya Drolia and in Praveen sort of, my lord, harmonized 11.6a existence and 16 existence.
Supposing the court actually overrules the respondent's plea that the agreement is disputed for X, Y, Z reasons, goes into it at some length,
My lord,
and then finds, no, what you're saying is not correct. There is an agreement, and the vitiating factors you attributed to it or that it's afflicted with, it does not exist. Very concrete findings are rendered. Will it still be open to the arbitrator in section
My lord,
16 to reopen it?
that assumes, my lord, that the court will give concrete findings in 11. Now, my lord, that is exactly what happened in that case. The High Court gave very concrete findings that an agreement did exist. This court said, no, you should not have gone that far. You should have stopped at the point where you prima facie found an agreement to exist. And because ultimately, my lord, a final determination like that in an 11 jurisdiction then will require evidence. Because then one party will say it is forged, one party will say, I did not enter into the agreement. So, my lord, that is how it has been resolved. Your lordship will just see that. I'll show that judgment, my lord.
which,
Volume 2, my lord, page 136.
which,
136, my lord, in the Arbitration Conciliation Act volume, my lord, Praveen Electricals versus Galaxy Infra. My lord, 2021 5 SCC 671. Oh, this is exactly what had happened in this case. I'll read the head note and I'll not show the dispute and I'll show the finding. Dispute regarding existence of arbitration clause, reference of such dispute when warranted, prima facie reviews the referral stage, prima facie examination to weed out manifestly ex facie non-existence invalid agreements and non-arbitral. Inadequacy of where such prima facie review would be inconclusive, inadequate matter requires detailed consideration, cross-examination of witnesses. Such cases held issue of existence to be referred to the arbitrator for determination as a preliminary issue. So this is how, my lord, this bench resolved this sort of dispute. Now, my lord, in this matter, what had happened was that the single judge went into it in great detail, and the argument, my lord, at page 146, para 8, Sri Shyam Diwan argued that it was a concocted document. And, my lord, the reply is at page para 10. Then there's a discussion, my lord, of the Vidya Drolia, etc.
Para 16.
16, my lord. Vidya Drolia is discussed, 8 and 11 is discussed, existence is discussed in para 17, 18, 19, my lord, and then the final Justice Ramana's judgment is discussed, and the ratio of this judgment is 22 and 23 at page 167. And, my lord, the facts are dealt with in para 29, where Justice Nariman says facts of this case remind us of Alice in Wonderland. And he says that this is a matter which requires investigation, and he then sends it to the arbitrator. And the judgment of the High Court is set aside insofar as it conclusively finds that there's an arbitration. That is set aside at paragraph 30. So the High Court found that there was an agreement. This court said, no, you should not, you should stay your hands. If you find that there is prima facie, there is an agreement, please, unless it is obvious that there is no agreement, supposing, my lord, even in institution, supposing there is a clause which says LCIA and your institution is MCIA, then the institution will reject. Or supposing there is actually no correspondence between the parties, and it is obvious, then you don't interfere in 11. But, my lord, the question, so this is so far as existence is concerned. But, my lord, fortunately for us, in this matter, we are not on existence per se, but this is the place where we are.
In some cases, not the big contract, what's happening is the arbitration is surfacing post-contract.
Yes.
After agreement is executed, a voucher is given,
Yes.
on it is written there's an arbitration clause. So that possibly doesn't come within the scope of this reference. But there also the question as to whether that arbitration clause is valid or not might come. Because there was no contract
But
arbitration
so often.
clause between the
it
parties.
happens so often, my lord. We go to the park a car in a hotel, they give you a voucher, it has an arbitration
Yes.
clause. It happens. My lord, there, unless, my lord, there also, my lord, I would go to the stage of saying that this judgment gives you the answer. You please direct an arbitrator, you decide as a preliminary issue whether at all an arbitration agreement exists. Please give full play to 16. Moment there is some detailed adjudicatory function which is happening, my lord, either the clause is patently void. There are some judgments, my lord. There are some commentaries referred to in Justice Thakkar's book that unless you can see on ex facie, my lord, the text is which is there also in Vidya Drolia, unless it is, my lord, it is manifestly and ex facie non-existent. If you see it and you say this is just, I mean, I will not refer it. For instance, there's an arbitration clause and it is from proceeds of crime. Or there's an arbitration clause where the Rent Act applies and both parties say, yes, the Rent Act applies. Then don't do it. But my lord, extreme cases always make bad law. So, my lord, 11 has to be given with respect, my lord, a narrow meaning.
And only good law services also from extreme cases.
Good law, my lord, also maybe, my lord.
One thing, so see, what is the basis for the submission that the scope of 11.6a is only to look into the question whether prima facie, why the court is approached for appointment of an arbitrator. And then, see here, the power is, the section is also, it clearly says the court may.
May.
So if the court finds that, of course, dispute is there, we need not consider it finally a prima facie.
Yes.
But the court, suppose, finds that here, now the court can take a final decision. And if he takes a final decision, whether can you say that no, the power is very restricted and you cannot take a final decision?
I'm not saying that.
And then the arbitrator shall again look into that decision.
What is the final decision the court will take? Will not
So
that-
therefore, see, going by this section, there's nothing which indicates that the power is very restricted.
Will not-
Because, see, the court is supposed to, going by the words, confine. So even after confining the examination on one question, whether this arbitration agreement is in existence or not, even after consigning the full consideration on that question alone, you are saying that that is only for the purpose of entering into a prima
My
facie.
lord, I will put it a little differently. Your lordship is right. It does not say it. Your lordship is right. In fact, to be fair, my lord, even in this three-judge bench, it is clarified that this was by a process of judicial interpretation. That is clarified, my lord.
It is just like see, suppose when the alternative remedy is there, the court need not exercise or invoke the power. But once it exercises it, can anybody sit over that? So here, court may, but once the court decides, yes, we will consider it and confining our consideration into the question of existence of arbitration, and then enters into a final conclusion on that. How can, just because 16A also permits that, how can the arbitrator again look into that
My
question?
lord, there may be two outcomes, my lord. One is the court finally decides there is no agreement. Then the matter is over, my lord. Matter is over. That's the
Definitely.
final decision.
Definitely.
There has to be, so my lord, if the case comes, so if there is a final decision that there is no arbitration agreement, my lord, then there is no appointment. Matter ends, my lord. So to that extent, there is a final decision. My lord, there is some interesting commentary on this issue which your lordship has raised, my lord, on final and prima
And on
facie.
the other question.
On the other question,
And if the court, after considering the agreement, finds that there is an arbitration agreement,
so my lord,
how that conclusion of the court can be interfered with
right now, my
in
lord,
exercise of power under 16.
in exercise of power under 16. Now, my lord, this was in fact the exact debate in SBP. This is exactly, my lord, the debate in SBP. My lord, to answer that question, yes, certainly, my lord, 11.6a can be read in that fashion. It can be read in that fashion. But as my lord said, my lord, as a matter of prudence, there are two options open to an 11.6 court, my lord. One is that I will finally decide.
Therefore, my question is it not for the court to decide? Taking into account the nature of the question, yes, it needs taking into evidence or consideration of evidence, etc. Party should be let in, permitted to
Then
let
yes.
in evidence.
Then go.
Then of course. But if the court thinks that no, this is a matter where conclusion could be
Easily.
arrived finally,
Easily.
then how can?
No, my lord, that this judgment does not go so far to say that it is, my lord, cannot be done. Again, my lord, fortunately or unfortunately, my lord, we are not on this aspect, but your lordship is right. If the court feels that it can finally decide
I
it,
put that question because at the outset itself you said the scope of 11.6a is that the court should confine the consideration only
Right.
in the question of
right?
existence or otherwise of arbitration agreement.
Yes, my lord. So far, so good.
And again you said that no 16, that should be prima facie conclusion. And then 16, where evidence can be, this can be permitted to let in evidence, and therefore the real consideration regarding the existence should be under 16. Whether to what extent that can be accepted.
My lord, I am only just placing, my lord, this particular green electrical judgment. Of course, it is 3 judges for your consideration, my lord. As my lord said, it is really a matter of prudence. It is not supposing, my lord, a 11 court comes to a final conclusion that X agreement does not exist.
Because that's a three-judge judgment and we are sitting
Abso-
in five.
absolutely.
Therefore, we have to put all those
Yes,
questions.
absolutely. My lord, I'm conscious of that. I'm only presenting, my lord, this is the view and the logic appears to be brought. I'm not saying that in an appropriate case, this court cannot, the 11 court cannot finally determine.
That is why may. That
May.
discretion is with the court.
Right. My lord,
May.
So, my lord, the question is, in exercise of that discretion, how would the court act if it can easily be decided? As the 3 judge says, it can easily be decided, it is manifestly and ex facie non-existent. Then the court will decide.
Legislative intention is not actually reflected from this, saying that the court is only supposed to take only a prima facie conclusion. There is no such legislative intention is indicated in or reflected in.
In this section, my lord, I just show the history and the intention, and my lord, the basis on which this view has been taken. My lord, your lordship is right. It will fit in the word may. How do you understand may? When you are exercising, you meaning, my lord, the 11 court is exercising the discretion. How will that discretion be exercised? The discretion will be exercised in the fashion that when you want to cut out the dead wood, not the Vidya Drolia view, when you are clear, when it is obvious, when it is something that can easily be decided, court can decide it and close the matter. No difficulty, my lord. But how to exercise that discretion, your lordships may consider, my lord. In that situation, when you need to take evidence, when you need to go into a deeper consideration, maybe you should not exercise the discretion. My lord,
But one more reason is there. You yourself admitted the fact that the court is having the exclusive jurisdiction to decide whether such an arbitration agreement exists or not. And it can also say no such arbitration agreement
my lord,
exists.
is
Then
no.
that would be the end of the matter.
And no is
If
no.
so, the court should also have the discretion, the power to say that yes, there exists.
My lord, if that power is exercised, my lord, and that will also have to be, my lord, read with 16. So 16 will also have to be given some meaning.
Harmonious construction.
Yes. My lords, what way it was resolved is that you went back to the old law and said with intervention of court, there is a different result. Without intervention of court, that's a different result. But 16 does not seem to make that distinction. And my lord, again, then we go back to the question of whether it's a judicial function or administrative function and it's not a court like, my lord, your lordships are sitting as a court. 11-6 court is not really such a court. My lord, that's what I wanted to, my lord, emphasize. It is not this court, my lord. It is not a constitutional court which is deciding matters of law, my lord.
But why was there was a change of judicial view about this being an administrative function to a judicial function?
Well, Lord-
11.6. Is 11.6 a judicial function or not?
My lord, my lord, please do not go into this judicial or administrative function. It has all sorts of, I will argue, my lord, it is an administrative function and therefore, my lord, the entire basis of 11.6a was removed. Please approach the question in a different way. As my lord says, my lord, there are 2 questions. The 2 questions are referred to in para 28 of the Law Commission report. 2 questions, my lord. I just want to show the Law Commission report since
Without one more thing. See, just with regard to
power.
the second proviso to 3A,
3A.
it says Chief Justice of the concerned High Court. So it is Chief Justice. But 6A, Supreme Court or the High Court,
My lord, the
it's
reason
not Chief Justice.
it's not Chief Justice. The reason for that amendment, my lord, is explained in the Law Commission report. The reason for that amendment was not to give it court powers, but
And the question is, and then see wherever the second proviso it only says Chief Justice of the High Court, but when 3A consciously the wording is the High Court or the Supreme Court.
Correct.
Then how can you say that it is only an administrative?
My lord, again, I don't want to go into the administrative.
We are only
My lord, the reason, I will also explain to your lordships, my lord, what was the reason for introducing the word court? That is reflected from, my lord, the Law Commission. It was not meant to change the character from and accept that it is judicial. My lord, the reason for it introducing the word court was only because, my lord, otherwise there would be some difficulties in the nature of the appointment. I will
One more reason is there. You yourself very specifically admitted the position that once exercising the power under 11.6a, the court arrives at a finding that there exists no arbitration agreement, then that would be the end of the matter.
That's the end of the matter.
It is in exercise of the same power, the court is now arriving at a different conclusion. No, there exists.
My lord, in,
How can you say that when it enters into the decision non-existence,
my lord, in
then it is final?
in non-existence, my lord, it happens all the time, my lord. Even in institutions, my lord, it does not change the color from administrative to judicial. In many cases, non-existence of arbitral, you go to an institution, you say, I want to go for arbitration. The institution says it does not exist. That's the end of the matter, my lord. Then you go to suit. That does not necessarily mean, and that's a final decision. The SEAC tells you that I'm sorry, this arbitration agreement does not exist. That does not necessarily, my lord, make it judicial. My lord, moment we go down judicial, administrative, court institution, my lord, we get into problems. So, and in fact, my lord, on this aspect, there was a lot of debate in section 8 and section 45. Justice Sabarwal took one view, Justice Sri Krishna took one view on this prima facie and finality. I'll show that, my lord, because
On 11.6 itself, view of the court had undergone
some change here and there.
yes.
So, my lord, to take away that, to come to a conclusion where this aspect, my lord, is limited. All these aspects, my lord, were looked at when bringing in 11.6. The my lord, question as to existence, my lord. I just may I my lord place the Law Commission report. It may address some of your lordships' concerns before I go to 16. Or would I, my lord, can I place 16 and then come back to
You
that?
proceed in your own way.
If I can place 16, my lord,
And
34, and then straight away Law Commission report to understand, my lord, where this debate is going. My lord, I'll just complete 16 and 34 and come back to the Law Commission report. And some of these questions which have now been raised, my lord, your lordship will see the discussion as to how it is there.
these questions are being raised as corollary to the issue we are.
Testing, my lord, the scope. Your lordship is testing the scope of 11.6.
Yes.
And that is a question which does fall for your lordship's consideration in some fashion. Lord, 16 is the competence of arbitral tribunal to rule on its jurisdiction. Arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement. And for that purpose, A, an arbitration clause which form part of a contract shall be treated as an agreement independent of the other terms. So this is, my lord, one, because normally a jurisdictional, a tribunal of limited jurisdiction cannot decide its own jurisdiction. This is the reversal of that policy statutory. A decision by the arbitral tribunal, contract is null and void, shall not entail ipso jure invalidity of arbitration clause, and plea does not, that your lordships have already seen. And then, my lord, 4, 5, and 6 is how the party proceeds. And 6 is a party aggrieved by such arbitral tribunal may make an application for setting aside an arbitral award in accordance with 34. So 16 remedy is under our law only pushed back to 34. But, my lord, I just want to show the contrast.
This preliminary determination in 16 will have to be challenged in 30.
34. My lord, I just want to show why we are having this 11 jurisprudence. This provision which I am showing to my lords has been, my lord, advertently or inadvertently left out by our legislature. We have been, my lord, more loyal than the king.
We can't presume Inadvertently left out.
or
by the
advertently, my lord, or
legislature.
inadvertently, it is caused, my lord, absolute chaos.
Has to be we proceed on the basis that legislature was conscious of what
In
it
96, my lord, of this, my lord. In fact, it came through in ordinance. My lord, this is the extract from the UNCITRAL website, which shows the model law. And here your lordships will see 16.1, which is very, very similar to what we have. 16.2 is also very, very similar to what we have. But 16.3 is something that is missing. Arbitral tribunal may rule on a plea referred to in paragraph 2 of this article either as a preliminary question or an award on the merits. If the arbitral tribunal rules as a preliminary question, it has jurisdiction. Any party may request within 30 days after having received notice of that ruling, court specified in Article 6 to decide the matter. So, my lord, in the UNCITRAL model law, what happens on the existence issue is that it is not really decided in 11, it is decided at the 16th stage. And the court has always, has the final word. So whatever the arbitrator decides, the court has the final word. Court can conclusively hold that there is no agreement. But this is the stage at which is normally it is done. Your lordships, just see the commentary. Introduction. Article 16 addresses 3 issues that may arise when the parties disagree as to whether their dispute ought to be resolved in arbitral or judicial proceedings. One is the separability principle. This is what NN Global, my lord, highlights, pursuant to which an arbitration clause forming part of a contract is to be treated as an independent or separate contract, separability. Another issue is the arbitral tribunal's power to make a determination as to its own jurisdiction to deal with the substantive claim and dispute known as principle of competence, affirmed and so on. So finally, 16.3 addresses the court's power to review as a preliminary phase, which unfortunately is missing in our, my lord, act. And had this possibly been there, we would have had very little jurisprudence on section 11, whether judicial, administrative, scope, level of inquiry. All this would have been gone to the 16th stage, where the court would have had a look at evidence, at the arbitrator's preliminary determination. Everything would have been dealt with at 16th stage. And at that stage, the court would have had full jurisdiction to look at everything, knock out bad agreements, continue with good agreements, existence, validity, stamping, everything would have been done. But this is unfortunately missing in our statute. Lord, this is 16. One more paragraph I want to show in 16, my lord. In respect of 16. And my lord, the importance of 16. Please see the 7-judge bench. 2005, 8 Supreme Court cases, 618. This unfortunately, my lord, I didn't file this because it's a very bulky judgment. So the request your lordship look at the book.
On what point you are?
My lord, just the scope of 16.
2015, 8 Supreme.
2005. 8 Supreme Court cases, 618, SPP and Co. versus Patel HL. On this portion, there is no inconsistency between majority and minority. Now, page 678, Justice Thakkar's dissent, please see 2 paragraphs only, 90. My lord, may also note para 87 just as by way of approach, where the international practice is recorded. My lord, the Law Commission, the international practice 87 para 87, lordship will note that paragraph on the approach. But please now see para 95 and 96. 87 says court should only verify clause is not patently void. That this seems to be the general trend. Now 95. Now let us consider section 16 of the Act. Section is new and did not find place in the old Act of 1940. 1940, it was the court who would ultimately decide jurisdiction. This is the bottom of page 678. Then, my lord, subsection 1 is analyzed, 2, 3, and 4 are analyzed. And, my lord, top of page 679, subsection 5 mandates the arbitral tribunal shall decide such plea where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceeding, make an arbitral award. Emphasis applied. Section 6 is equally important, expressly enacts that a party aggrieved by an arbitral award may invoke 34 for setting aside. The provision appears to be made to prevent dilatory tactics and abuse the immediate right to approach the court. If an aggrieved party has the right to move the court, not have been possible to preclude the court from granting any stay or interim relief which would bring the arbitration proceedings to a grinding halt. Provisions of 16(6) read with 5 now make this legal position clear, ambiguous, and free from doubt. Then, my lord, 96. Section 16(1) incorporates the well-known doctrine of competence till competence, recognizes and enshrines important principle that initially and primarily it is for the arbitral tribunal itself to determine whether it has jurisdiction in the matter, subject, of course, to ultimate court control. It is thus a rule of chronological priority. Competence, widely accepted feature of modern international arbitration, allows the arbitrator to decide its own jurisdiction, including ruling on objection with respect to existence of validity, subject to final review by a competent court. So, my lord, the policy of 16 is first bite of the cherry with the arbitrator, second bite of the cherry, and the conclusive one, second call, is with the court. The court will ultimately decide all these questions at an appropriate stage. And, my lord, there are various commentaries which he has put in after that. The learned judge has put in, has also referred to Renu Sagar, my lord, on this. So, my lord, this paragraph just shows, my lord, what is the purport of 16. So, the submission, therefore, is, my lord, that certainly 11 has its own play, but 16 is also there, my lord. It is not made subject to 11.
This is the concurring view or dissenting?
This is the dissenting view, my lord. But on this,
paragraph 12 of that letter, which sets
12.
out the majority view.
12, my lord, I'll leave it.
The view of Justice Balasubramanian,
Balasubramanian.
speaking on behalf of the bench.
Right. Section 16 of the Act only makes explicit what is even otherwise implicit, namely that the arbitral tribunal constituted under the Act has a jurisdiction to rule on its own jurisdiction, including ruling on objections with respect to existence or validity of the agreement. Subsection 1 also directs arbitration clause which forms part of a contract shall be treated in agreement independent of other terms of the contract. Also clarifies decision by arbitral tribunal the contract is null and void shall not entail ipso jure invalidity of arbitration. Section 2, subsection 2 enjoins that a party wanting to raise a plea that the arbitration tribunal does not have jurisdiction has to raise that objection not later than submission of statement of and that the party shall not be precluded from raising.
Come to perhaps the next page,
Next
towards
page.
the middle,
Yeah.
say after B, the question in the context
Is what is the scope of the right conferred on the arbitral tribunal to rule on its own jurisdiction and the existence of arbitration clause envisaged by 16(1) once the Chief Justice or the person designated by him had appointed an arbitrator after satisfying himself conditions of exercise. Prima facie, it would be difficult to say, in spite of the finality conferred by 11, such a decision, Chief Justice, arbitrary tribunal can go behind the decision, rule on its own jurisdiction on the existence of arbitration. But this is
the view.
this was the view taken, my lord,
This
but
has been legislatively overruled.
this was legislatively, my lord, overruled.
Now, if you come to how Dodia deals with it, please come to paragraph 138 of Dodia.
Of Drolia.
And then particularly at page 140. The actual procedure to be adopted is laid down there. You can read paragraph 138.
Lord, in fact, this discussion of prima facie view starts at 134 also.
We can start with 138 because actually, it splits up into 3 categories.
My lord, there is a problem with Bokhara.
Ah.
Because Bokhara has been curtailed, my lord, legislatively, specifically, and there are some comments in Justice Ramanna's judgment which say that even the Bokhara view is not the view today.
That's right. But if you come to page 139 and 140 to be more specific.
139.
Paragraph 139, 140, page 147.
My lord, this is, we would not like to be too prescriptive. This is page 147 of the compilation.
So you can read that.
Of the, my lord, the first volume. This, of course, was in the context of arbitrability and subject matter arbitrability.
But you
Specifically,
just see, if you read it, you'll see.
we would not like to be too prescriptive, albeit observe that the court may, for legitimate reasons to prevent wastage of public and private resources, can exercise judicial discretion, may to conduct an intense yet summary prima facie review while remaining conscious that it is to assist the arbitration procedure and not usurp jurisdiction of the arbitral tribunal. Undertaking a detailed full review or a long drawn review on the referral stage would obstruct and cause delay, undermining the integrity and efficacy of arbitration as a dispute resolution mechanism. Conversely, if the court becomes too reluctant to intervene, it may undermine effectiveness of both the arbitration and the court. There are certain cases where the prima facie examination may require a deeper consideration. The court's challenge is to find the right amount and the context when it would examine the prima facie case or exercise restraint. The legal order needs a right balance between avoiding arbitration obstructing tactics at referral stage and protecting parties from being forced to arbitrate when the matter is not clearly not arbitrable. Accordingly, when it appears prima facie review
Where it's important.
would be
These are the words which are
inconclusive
important.
or on consideration inadequate as it requires detailed examination of the case which I cited, Praveen, the matter should be left for final determination by the arbitral tribunal selected by the parties by consent. Underlying rationale being not to delay or defer and to discourage parties from using referral proceeding as a ruse to delay and obstruct. Such cases, a full review by the court at the stage would encroach on the jurisdiction of the arbitral tribunal, violate the legislative scheme, allocating jurisdiction between the courts and arbitral tribunal. Centralization of litigation with the arbitral tribunal as the primary and first adjudicator is beneficent as it helps in quicker and efficient resolution of disputes. Then, my lord, court would exercise.
Para 144, now you may read. Para 144.
As observed earlier, Patel Engineering explains holds that Section 8 and 11 complementary in nature, both relate to reference. Section 8 applies when the judicial proceeding pending, application filed for stay of judicial proceeding, reference after. Amendments to 8 have not been omitted. Section 11 covers the situation parties approach. Mayawati Trading, in our humble opinion, rightly holds that Patel Engineering has been legislatively approved and hence would not apply even post omission of 6A as to Section 11 of the Act. Mayawati Trading has elaborated on the objects and purpose and history of the amendment to Section 11 with reference to 6A to elucidate the section as originally enacted, facsimile with Article 11 of Law of Arbitration, which the Arbitration Act, referring to the legislative scheme, Section 11, different interpretation, Law Commission, it has been held omitted 6A would continue to apply and guide the courts on its scope of jurisdiction at stage 1 pre-arbitration stage. So, my lord, this is the.
Therefore, what you're trying to put to you is from Patel Engineering, paragraph 12, we pointed out majority takes the view. The court in 11(7) holds that there is an arbitration agreement exists.
Then it's over.
Then it should be over
Over.
in terms of the majority, not open to the arbitrator to rake it up in, the parties
At all.
to rake it up, number one. Now, SPB, the majority has been overruled and
Registered.
the text is changed because
Text
of
is-
the introduction of 6.
Correct.
Now, interpreting this Dolia
Yes,
and the earlier judgment appears to be one way of doing it is
Yes, ma'am.
that the High Court or perhaps the court under Section 8, when it refers in a case which is a little nebulous,
Right.
where, prima facie there is an agreement, exists an agreement. But the court does not want to really finally hold there is an agreement.
It can then.
Device can be to actually expressly make it clear that, we are doing it in this way. We will not take away your right
Under
to
16.
agitate it under Section 16.
Correct.
One that might perhaps hold the key
Yes.
to solving this problem as to in which case the parties are yet free despite a finding.
Yes, ma'am.
Or the second thing is the court should not go elaborately into it.
Correct.
You begin with that.
Right.
These are
Or if it is obviously, but not manifestly, if the court feels that this can be closed quickly, then the court can close it.
matter is over.
So, my lord, it is really as.
So it really depends on what the court will really get to say.
Right.
First of all, understanding the limited nature of its jurisdictions at that stage.
My lord, the practical situation is this. Your lordships are a court. The High Court is a court. Courts want to decide.
That's it.
That's the normal,
So when
that's the normal, my lord. It's very difficult for the court to say,
what the court can do is,
to step back.
the court say, prima facie, step one, there is an agreement. It is in writing. It discloses that there is an arbitration agreement. Okay. X, Y, Z factors are urged against its validity, even against its existence.
Even
The
existed.
court finds that these are matters which are better gone into in a section 16.
Correct.
So there the court says there is an agreement. We leave it open to you to take all your preference in section 16.
The Alice in Wonderland case, my lord.
The real solution is the court may make it clear. that
Court
you are
will
not
make it clear.
Foreclosing your right under section 16. The matter will
In
be
fact,
over
my lord,
quickly.
your lordship, that clarification has to be given, my lord. In fact, in Praveen Electricals, that was specifically made
Once
clear.
you do that, they enter the matter. You don't have to sit in for years together, like 11 years in Jammu and Kashmir, where you spoke about. I mean, it can be avoided if you have this.
My lord, it is basically something which is against the nature of the judge. The judge is there to decide issues. But here, my lord, the judge has to step back and leave it to somebody else. It goes against the judicial, my lord,
It's a change in law. Actually.
nature.
The legislature has
The legislature
changed the
wants-
text of the act, and therefore SBP has been overruled. We have to accept that
We-
unless we hold
we have
that
to accept
the
that.
judgment is wrong.
We have
Therefore,
to.
para 12, which appears to suggest that if once a court enters a finding regarding even the existence, there is a bar under section 16. That may not continue to hold good, but the care must be taken both in the exercise of jurisdiction under section 11, 8, and also making it clear appropriately in the order.
Lordships will clarify.
If that is done,
There should be no problem.
clarify the whole thing.
There should be no, my lord, that actually happens in cases where it doesn't go to court. It happens, my lord. You appoint subject to this, and then you go ahead.
Go ahead.
And you first preliminary point you raise, it is void, it is contrary to competition law, it is, etc., etc.
As they would say that the cause of arbitration will be served even by those who stand and wait. Not necessarily that by not adjudicating, you are doing injustice.
Yes, my lord. In fact, this is a case where the court need not,
Step back
should, well, it's difficult. It is difficult
by,
because
by tendency.
tendency, and my lord, if your lordship sees some injustice, then it is very difficult to tell a court, now you don't look at it, my lord, please send it to the arbitrator. That is something which is, as my Lord Justice Bose said, the case of the piece of paper with the arbitration clause. The court wants to step in. So, my lord, there, of course, there's a Consumer Protection Act.
Praveen was a case where they found that there's no existence. Yet Supreme Court did not disturb because, there are a lot of evidence.
There were a lot of
that had to be
evidences.
taken into account.
It was a concocted
That,
agreement. It seems like it.
That Alice in Wonderland analogy came in only because of the situation prevailing there.
That's right.
It was not in existence.
Not in existence.
I have forgotten how to speak English.
That's right.
See, if you do online transaction, the offer and acceptance is complete, then the goods arrive, and in that product description or something, there is inserted an arbitration clause.
Yes,
That is post-contract.
post contract. My lord, there, of course, there is another point. That's a consumer
Okay,
dispute.
we don't want to engage in that, but
There, my lord, then that it may not be arbitrable at all because it may be a consumer dispute. There are
somebody may like to go to a suit court also.
somebody may like to go to a suit.
Then that section 8 question.
Section 8 question will come.
But we must not get derailed too much because here we are on a stamp.
We are on a very limited.
So therefore, otherwise this discussion.
Otherwise, this
just
discussion,
go
my
on
lord,
and go on.
will continue. My lord, let me then, my lord, just place 34 and 41. SOR. Don't place it.
One more thing, see, at the time, the decision in SPB was rendered.
Correct.
The position of 76 was different.
6 was different.
It was totally different.
Totally. Totally. Well, in fact, therefore, 6 was interpreted in that particular way.
And again, then section 7 was also there. I mean, subsection 7.
7 is still there, my lord.
But then
Seven is still there. Unfortunately, it's there. Seven is still there.
By the present ones, after 6B, it is 8.
No, that may be in the 2019 it has been delayed. 19 it has been delayed.
Seven also 60.
Seven has gone in 19. It is still there.
Up to 9. That is Act 33 of 29.
That has not been, my lord, notified, that portion.
That is also.
That's
just like.
so, my lord, it is unclear what the law is. Some portion is deleted, some portion is not notified. There is a very nice chart.
In SBB, section 7 was also taken into consideration.
Yes, yes,
But section 6 at that point of time, it was totally.
totally.
But still in paragraph 15 of SBB, there is a finding that that decision is judicial, in excess of judicial power.
Yes, my lord. That's where the
It's not administrative.
it's
Paragraph 15 very categorically held that it is judicial in exercise of a judicial power.
my lord. I just want
Paragraph 15.
right, my lord. May I just now show, my lord? Yeah, we've shown section 16, my lord. Your lordship will just see two more sections, and I just show the comment. My lord, the law commission. At 4 and 45. My lord, just see before the law commission. Please see. I just complete the act, my lord, and then come to the law commission, which will perhaps assuage some of these issues. My lords have seen 16. Just complete it. Please come to 34 for me. Yes, yes. Mayawati also.
Followed by in
Praveen.
Ravi and-
Please, Judge. By Vidya Jolia. That seems to
That appears to sort of prescribe the law, apart from overruling. Instead of the limited nature of stated level.
right. Yes,
See
yes.
whether it exists, that's it.
My lord, Vidya Jolia, little bit of fine tuning, little bit may
A
have.
little bit.
It may have.
You're right.
My lord, just see 34. 34 is a provision, my lord, which is effectively a copy of the model law. And the reason I am showing 34 is, my lord, 34 has two limbs. 34, my lord, 2A and 34 2B. 34 2A is a defense raised by a party. 34 2B is something that the court can find by itself. There is a distinction, my lord, normally people do not notice. Then your lordships will note that 34A has 5 different subheads. Your lordships have 34 2A. Arbitral award may be set aside by the court only if the party making the application established so and so, one party is under incapacity, etc., etc. There are 5 subheads of 34 2A.
2019, 5 and 6 years.
34 2A has 5 subheads and 34 2B effectively has 2 subheads. Well, not each of them are different, and there is a reason I am raising this, my lord, because it has some relevance to Vidya Jolia also. My lord, may just see 34 2A 2. 2A2 says the arbitration agreement is not valid. So it is invalid under our law. That is one situation where the agreement itself is invalid. Validity may possibly also include existence. Then, my lord, please contrast it with Roman 4. The arbitral award deals with a dispute not contemplated within the terms of submission or contains matters beyond the scope. My lord, this is little different. 2 is validity of the clause. 4 is a dispute which does not fall within a clause. My lord, this may be relevant for Vidya Jolia. Then, my lord, a different heading is now 2B1. 2B1 is the subject matter of the dispute is not capable of settled by arbitration. So there is subject matter arbitrability. This is the issue, my lord, which was raised in Jolia. Namely, that even if there is an arbitration clause on the face of it, but in fact it is barred by landlord tenant. And then, my lord, the next heading is public policy. So public policy is treated differently. Dispute not capable of arbitration is a matter only for the court to decide, because the court will ultimately, even if there is an award, even if nobody raises it, court will decide. So, my lord, this is 34. Your lordship will just note this. And, my lord, 45. The relevance of this, my lord, I'll come to later. But 45. 37. Conditional appeal. We'll leave it. 37 to 37 is the appeal provision, which shows only there's a conditional appeal in 16. And then, my lord, 45 is in part 2. My lord, I am only, this is actually under the New York Convention. We are stricto sensu not concerned with. But it uses the expression unless it prima facie finds that the said agreement is null and void, inoperative or incapable of being performed. So, my lord, if your lordship steps back and now looks at the Arbitration Act in entirety, Section 8 uses the word validity. Section 11 uses the word existence. Section 16 uses the words existence, validity, jurisdiction. Section 45 uses the word null and void, which means validity, inoperative, incapable of being performed. In different sections of the same act, very different phrases are used.
Have you given this
I've given
description in your note?
I've given the description at page. My lord, we will have to give some meaning to the text also. So where existence is used, please use existence. Where existence or validity is there, please. So, my lord, after all, the legislative, my lord, intent is reflected best from the language. So, my lord, this is so far as the act is concerned. Now, my lord, the most important amendment came in 2015. And again, my lord, we are going away slightly from stamping, but it has some relevance. Please now see the Law Commission report, which has been now, my lord, referred to in n number of judgments. There are 6 or 7 paragraphs. I would request your lordships to have a look at that. My lord, this is in Roman part 4, put it in the 4th word. This we can leave. I have given references to the statement of objects and reasons of each of the acts, 96 Act, 2015 Act, 2019 Act, what are the relevant? I'm not going into it, it's there in the note. I'm curtailing this. The lordship will straight away come to the 246 Law Commission. And please note, my lord, in this volume, pages 22 to 27, 49 to 51, and 52 to 55.
Volume.
Good.
No. Just
Both.
repeat these pages once.
22 to 27, the main discussion, 49 to 51, and 52 to 55. Because this is the legislative background to the bringing into existence of 11. My Lord Justice Rastogi has got this volume.
We have volume 4.
Volume 4. My Lord, the report starts on page 1 and the relevant pages are 22 to 27, which are the main pages. My Lord, 22 starts. I'll just read a few portions, my Lord, just to put this in perspective. Delays in court before the arbitral tribunal investment treaty race. This refers to the White Australia case. Judicial intervention in arbitration proceeding adds significantly to the delays in the arbitral process and ultimately negates the basis of arbitration. Two reasons can be attributed. First, the system is overburdened with work, not sufficiently efficient, dispose cases, especially commercial cases, speed and dispatch. My lord, this is really a reason which is beyond my lord, us at the moment. Secondly, the bar for judicial intervention, despite the existence of Section 5, consistently been set at a low threshold by Indian judiciary, translates into many more admissions cases in court arise out of related acts. So, my lord, 22 identifies two problems. 23, your lordships will skip, which is the wider problem. My lord, we are not concerned with this at this stage. 24, two further sets of amendments proposed. First, it is observed a lot of time is spent for appointment of arbitrators, very threshold of arbitration proceedings. Applications under 11 kept pending for many years. In this context, Commission has proposed a few amendments. Commission has proposed changing the existing scheme of the power appointment being vested in the Chief Justice of the High Court and the Supreme Court, and has expressly clarified that delegation of power appointment as opposed to finding regarding existence nullity shall not be regarded as a judicial act. This will rationalize law and provide greater incentive to the High Court to delegate the power appointment to specialized. So, my lord, this is one recommendation. 11.7 recommendation, my lord, is also there. Then your lordships will come straight away. So, this is by way of background. My lord, the main paragraphs are 28 to 33. These are, my lord, extracted in Mayavati also. But there is one paragraph, according to me, my lord, 29 is the critical paragraph which will address large number of issues. May I read 28? The Act recognizes situations the intervention of court is envisaged at pre-arbitral stage prior to the constitution of the tribunal, includes section 8, 9, 11 in case of part 1, section 45 in case of part 2.
Which one you are reading?
Well, not para 28
Oh, wait.
at page 20.
Yes.
Yes. So, my lord, it recognizes situations the intervention of court is envisaged at pre-arbitral stage. Sections 8, 45 and also section 11 relating to reference to arbitration appointment directly affect the constitution of the tribunal functioning of the arbitral proceeding. Therefore, their operation has a direct and significant impact on conduct of arbitration. Section 9, solely for the purpose of securing interim relief, although having potential to affect the rights, does not affect the conduct of arbitration in the same way. It is in this context, Commission has examined deliberated the work. Now, my lord, 29. I rely on 29 as an understanding, my lord, of all the provisions. The Supreme Court has had occasion to deliberate upon the scope and nature, italicized, of permissible pre-judicial intervention, especially in the context of Section 11. Unfortunately, however, the question before the Supreme Court, framed in terms of whether such power is a judicial administrative power, which obfuscates the real issue underlying such nomenclature description as to the scope of such powers, i.e. the scope of arguments which a court / Chief Justice will consider while deciding whether or not to appoint an arbitrator, i.e. whether the arbitration agreement exists, whether it is null and void, whether it is voidable, etc., and which of these it should leave for decision of the tribunal. So, my lord, first, scope. What is the scope of 11.6? Second, my lord, what was put to me by my lord, Justice Ravi Kumar, nature of such intervention. Would the court consider the issue on a detailed trial, whether the same should be decided finally or left for determination? So, my lord, these are conceptually two issues that your lordships will have to decide on 11. What is the scope, which is what we are actually concerned with. We are not concerned with, my lord, the second portion of nature of intervention. What is
32 and 33 you have read? Look, that,
30, no, I have read only 30, then 32 and 33.
please read that one.
32, I'm reading that one. I have only come to 29, my lord. Then after a series of cases, Supreme Court held that it's a judicial power. Underlying issues were clarified by Bogara. So, my lord, then 30 Bogara set out. Commission is of the view that in this context, same test regarding scope and nature as applicable in context 11 should also apply 8 and 45, since the scope and nature judicial should not change depending on party intending to defeat arbitration agreement, refuses to appoint an arbitrator, terms of the arbitration, moves the proceeding before judicial authority. In relation, my lord, this is to answer the question which fell from the tribunal. In relation to the nature of the intervention, the exposition of the law is to be found in the decision of the Supreme Court in Shinetsu versus Aksh Optify, my lord, 2-1 judgment in the context of 45, where the Supreme Court has ruled in favor of looking at the issue controversy only prima facie. Justice Sabharwal took a view, Justice Sri Krishna took a view, and there was a split verdict. It is in this context, Commission has recommended amendments to the Section 8 and 11 of the Conciliation Act. Scope of judicial intervention is only restricted to the situations where the court judicial authority finds that the arbitration agreement does not exist or is null and void. Even this was not accepted by the legislature. Even this was not accepted. The legislature cut out null and void. It went one step further and said existence. But I actually, my lord, personally, my submission is that there is really not much difference between existence and validity. It may be that the word existence may also in some way cover validity. It is not merely that your lordships will see on a piece of paper an agreement is there. Maybe some inquiry will have to be there. Is there some consideration? Is there something will have to be said? So, my lord, the recommendation was exist, null and void. Inoperative, incapable of being performed, not included. So, existence and null and void. Similarly, my lord, insofar as nature of intervention is concerned, recommended in event court is prima facie satisfied against the argument challenging the arbitration. It shall appoint the arbitrator, refer the parties to arbitration. Amendment envisages the judicial authority shall not refer only if it finds that it does not exist in arbitration agreement or it is null and void. If the judicial authority or the opinion prima facie arbitration agreement exists, shall refer the dispute, leave the existence to be finally determined. However, the judicial authority concludes the agreement does not exist, conclusion will be final. So, my lord, this was the understanding in Shinetsu and this is how it was. And, my lord, the amendments which were suggested are there. So, this is, my lord, the critical part of the report is paragraph 28 to 33.
Para 10 also, I mean, after para 10 of we are reading Mayavati actually.
Oh, your lordship is reading Mayavati.
So,
I am reading it from the report, my lord, because
it is incorporated in the.
my lord, para 8 to 14 of Mayavati actually summarizes it. But interestingly, my lord, one or two of these paragraphs are not mentioned in Rolia. So therefore, my lord, I read it from the.
Therefore, the trick lies really in the manner in which both you approach it and how you couch the order.
How you couch the order.
If you say that there are contentious issues, we are not fully satisfied, but there is prima facie an agreement, say so, leave it to the arbitrator. Fine.
Good enough. So, my
Not
lord,
matter.
fortunately, my lord, we are not on existence today.
And
Because
we are on
the larger issue.
way out instead of
We are on not even we are on stamping, my lord, which is one larger area. My lord, we have gone past existence, we have gone past validity, and we have got to admissibility. So, my lord, today we are debating what is to be done. Stamp. So that is in fact, my lord, there can be no dispute. I say this with authority, my lord, that an unstamped agreement exists and is valid in law. My lord, they cannot be disputed that transaction is a valid.
Repeat yesterday's question, whether under section 35 of the Stamp Act or 34 of the Maharashtra Act,
34 and 33, 35 I have to answer, my lord.
whether it amounts to adducing evidence when an applicant under section 11 produces the agreement, whether it is adducing evidence, whether it's in that sense that it's straight away attractive.
My lord, whether 33 and 35 are attracted or not. Can I, my lord?
First of all, in section 11 application.
Yes, your lordship had asked me that question, my lord. You produce the document.
Yes.
Is that admission into evidence or not? And whether as a result of that, 33 and 35 engages.
That's the only issue.
Right. Lord, I will go one step behind that and I will say that 33 and 35 is not at all triggered. And I will show, my lord, how 33 and 35 is not triggered, my lord. So, my lord, this is the 246 Law Commission report. I have also set out, my lord, in the note, the relevant pages of the high-level committee. This is Sri Krishna committee, my lord. I am not going to read it in the interest of time, my lord, but that is at page 84 to 87 of this volume. The report starts at page 75. The relevant paras are 73 to 76. My lord, it is in the note. I am not reading it out. It doesn't advance matter much further.
Yeah.
But it also says that SBP has been overruled. You have to consider the aspect of speed, etc., etc. In fact, now under the new regime of high-level committee, the courts are completely excluded. from the appointment process.
Yeah.
There is a complete exclusion of courts from the appointment process. Courts will come in either at 16 or 34 stage to, my lord, give the final stamp of approval or rejection. So it's not that the courts are excluded. The intervention of the court has been, my lord, shall we say, deferred, or the application of mind and detailed understanding of the courts has been deferred, my lord, to a later stage. Because that is, my lord, how the legislation is structured. That first you go to the arbitrator and decide, and questions of jurisdiction, those 4 headings, my lord, I'd shown, whether it is subject matter arbitration, etc., all will go there. Now, my lord, 3 judgments. Your lordship is looking at Mayavati. May I just show the other 2 judgments before that? My lord, Duro Felguera. Please see Duro Felguera.
Which volume?
My lord, volume 2.
It's at page 64.
Duro Felguera
There are page 64.
Yes.
of it.
has been approved in Mayavati specifically. So, my lord, I just want to show the reasoning. So, Duro Felguera begins at page 64. My lord, the merits of the matter are really not much of consequence here. I have put it out in the note. There was a supplementary judgment by Justice Joseph, Kurian Joseph, of which 4 or 5 paragraphs are important.
Yeah.
Because they have been approved, and that is the approach which has now been accepted. Justice Kurian's judgment starts at page 94.
That is the first judgment.
Sorry,
That is the first judgment on 6A.
that's the first judge. That is the first judge, Your Lordship.
6A has been interpreted in number of judgments
Right.
in a different way.
Right.
That is for the guidance.
This is the first one.
First, we are only on the limited issue.
Stamp.
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 If it is unstamped, insufficiently stamped, what will be the scope
Right.
for the court on the social level?
Right.
Let us confine back to that.
Right. So, my lord, I am saying that this is the test
Go on
on other things.
multiplying on a different.
I know.
context.
I agree.
For us.
It's not. It's not.
Otherwise, this is an unending debate.
Unending dispute. My lord, I will
And,
go.
more the discussion, more
More
the
interesting points. come.
opening the questions to be
Right.
answered.
Right.
So we confine back to
Stamp.
this.
Stamp. Stamp.
Stamp Act.
Stamp. So, my lord, I am showing this only in the context of stamp.
Yes.
I am showing, my lord, 3
But
judgments.
that was not the case in reference to Stamp Act.
No, my lord, but the proposition which was approved is the proposition which will apply even for
Yeah,
stamp.
52, 53. something.
Yes, yes. I'm saying that's the test. Please apply that test. That's what I'm saying, my lord. It is not on stamp. But, my lord, it gives the test.
Same problem comes in. Suppose it's just sitting in 482. It's just sitting in a criminal revision. Scope is different. But the parameters when we test is not overlapping. And judge is sitting in 226 and 227. And judge is sitting in 227. Parameters are quite different.
Correct.
But when we, as a judge, when we said
Correct.
almost the same parameters go on overlapping.
Right.
And a lot of confusion goes on. The scope in 226 and 227 and 227.
Correct.
Of course.
So, my lord, I am only showing this. Therefore, I said, my lord, I am not going to the facts of this case.
Para 59 is what you want to do.
My lord, 3 paragraphs.
Para 59.
4 paragraphs, my lord. I've noted the paragraphs, my lord. First, he starts, my lord, after analyzing 47, 48. My lord, 48 is referred to in Justice Nariman's judgment at page 94. That's why I'm mentioning.
59 is what is important.
59 is important. My lord, 56 says that this is one of the first cases. And my lord, 59
59 is sufficient.
is sufficient.
That's what we.
59 is sufficient. So, my lord, I rely only on 59.
Para 59.
59. The scope of power under so-and-so was considerably wide in view of the decision of the SPP. Position continued till the amendment. After the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. The legislative policy is essentially to minimize the court's intervention. And intention ought to be respected. This is, my lord, according to me, nothing more seems to be irrelevant. Thereafter, my lord, the next judgment I've referred to, my lord, I've referred to in my note, my lord, is Uttaranchal Pur Sainik, which, my lord, which also deals with this aspect, 2 paragraphs there, and then straight away my Uttaranchal Proof Sainik is in page 127. This is, my lord, I believe my Lord Justice Rastogi was also a party.
myself there, this Hindu Luthra is author. You got it.
Page 127. No, really, the relevant paragraph is 7. This starts at page 127 of this compilation. It's two-judge bench. Paragraph 7, my lord, really deals with the issue because the issue there was whether limitation should be gone into or not. But my lord, what is important is I have mentioned the paragraphs. It gives the history of 2015 amendment, etc., etc. And then my lord, 7.7 Law Commission report and 7.8 it relies on Duro Felguera, and my lord, 7.10. In view of the legislative mandate contained in 11.6a, court is now required to only examine existence. All other preliminary or threshold issues are left to be decided by the arbitrator under 16, which enshrines the competence. And then, my lord, 7.11 explains in some detail the competence principle and said it is subject to the court's control. It is not that it is completely the arbitrators like tilting at windmills can do whatever he wants. There is some court control. And my lord, 7.12 is also important. The legislative intent is party autonomy and minimal judicial interference. Also at the pre-reference stage is also emphasized on 7.12 and 30. No, this is a little more elaborate. And then your lordship comes to Maya. 115, which your lordship was, my Lord Justice Joseph was already looking at. Lord, this case also was not a stamp case. It arose out of accord and satisfaction. And my Lord, the importance of this case, if I can say, is that it sets out in one place the legislative history. So it can easily be, my Lord, paras 8 to 14 set out the legislative history. The finding of the court, my Lord, not before your lordships see the finding, please note paragraph 10, the legislative overruling of SBP. Lord, please come to para 10, 125. This being the position, it is clear that the law prior to the 2015 amendment that has been laid down with this court, which would have included going into whether a court of satisfaction takes place, has now been legislatively overruled. This being the position, difficult to agree with the reasoning concerned in the aforesaid judgment. And as section 11.6a is confined to the examination of the existence in italics of an arbitration agreement and is to be understood in the narrow sense as laid down in the judgment in Duro Felguera at 48 to 59. So, my lord, these are three general judgments, my lord, on the scope of 11.6a, apart, my lord, from Vidya Drolia, which I will deal with separately. So, my lord, with this aspect, I'm not going to show World Sport Group, my lord. I mentioned World Sport Group. World Sport Group was a case under section 45. And in World Sport Group, three separate expressions were defined: null and void, inoperative, incapable of being performed. So, my lord, a non-stamped document at the highest may be incapable of being performed. At the highest. Even that, my lord, may not be correct because it's a curable defect. But it is certainly not null and void. My lord, in fact, this phrase null and void, which is used in part 2, is actually only void. Null and void means void. This is in the English text, it is null and void. In the French and Spanish text, my lord, it means void. So if an agreement is void, then perhaps, my lord, it will go to validity. So, my lord, there is narrow existence, then there is validity, and, my lord, then admissibility. So, my lord, we are at stage 3. So, my lord, existence, certainly it exists. I would say that a unstamped document is also valid, i.e. it is not void. So, my lord, so far as 11.6 is concerned, 6a is concerned, one word I would like to emphasize, my lord, which is confined. the language of 11.6a, my lord, I understand that after the recommendations of the Law Commission were placed before the government, my lord, there was some rethink and 11.6a was rejigged. And the expression is, first word which is used is confined. And confined, your lordships will note, Lord, we have mentioned some dictionaries, etc. Confined means circumscribed. Confined means, not Lakshman Rekha. Confined means that it is within that limit. So the 11 court will have to confine to the examination of existence and nothing more. So, my lord, this is also part of the legislative policy.
When we come to section 20 of the contract, Act,
20 of the contract. Not voidness.
voidness.
My lord, none of the section from 20 to 30, which includes contracts which are void, cover an unstamped agreement.
That's right. We are asking you for some other purpose.
Right.
Supposing a contract is alleged to be void as distinct from voidable.
Void ab initio.
Void ab initio.
Void ab initio.
If an agreement is void ab initio, can it exist?
My lord, there is a little gray area there. My lord, two words have been used. One is existence, one is validity. According to me, my lord, it may existence may encompass validity also. So, my lord, it may be argued that existence includes validity, though the legislature has used two different words.
What will be the effect of the contract being declared voidable under the Contract Act? Because
Those are the next few sections, my lord. That is an option which is open, my lord. I'll show those sections of the contract.
So, would a voidable contract, can it be said that it exists?
It exists, my lord. It certainly exists.
It exists.
It exists. So, my lord, subject to the contract being void, my lord, and therefore, at least in my note, I have, my lord, submitted that formal validity will have to be established to some degree before the 11 court. You will have to, at least as an 11 judge, see whether you know their basic ingredients are.
You got a finding finally.
My lord, then we are back to
You got a finding.
then, my lord, we are back to the other question.
That's correct. So
Of-
ultimately,
of-
11 court. 11
My lord,
court
then we are on the standard. My lord, one is scope, one is standard, my lord.
A sort of nebulous area.
You
You
then,
say leave it,
But, my lord-
but it should be left open. There's a
Yeah.
whole point. Problem arises where
if it's not left open.
if it is not,
If it's not
left open.
Yes, absolutely. That's the only way really to reconcile 11 and 16. It'll have to be left open. Otherwise, my lord, then whether one likes it or not, a court is a court, my lord. Then an arbitrator will be very chary of however much we say that Article 16 is very wide, give it its full play. No arbitrator will really then want to revisit what a court has done. That's the
Yeah.
practical implication. Triple right. Well, not, I just, it's not in the compilation. I'll just tender this for the purposes of completion. We mentioned it at page 23. The word confined, what it means. Wait. Second last entry on the right column. To keep within circumscribing limits, to restrict. Just, my lord, it's just an understanding of the movement. As your lordship said in the other matter, one has to confine to only, my lord, the guidelines. Here I have to confine only, my lord, to Stamp Act.
Once made, we have to remind ourselves that while deciding applications of section 11 is not a court.
It's not a, my lord, full-fledged court of record in the way that your lordships are today.
So this back of the mind this goes on all the time. That sometimes creates a lot of problems.
And, my lord, the instinct of the judge is to decide. If the judge sees, my lord, there is a lot of criticism of our courts that we are intervening. Lot of criticism. But my lord, my personal view, and I want to make this clear, is that the reason that the courts are intervening is because there's serious defect in our legislation in the Arbitration Act. We have eliminated 16 appeal. We have, my lord, not looked at 34 properly. My lord, there are any number of reasons where the courts are intervening because we have not got the proper statute. So it's very easy, my lord, to blame courts because courts will interfere or intervene if there is injustice.
One suggestion which I heard was, when a court deals with section 34, the court should not be burdened with the obligation to furnish reasons.
Permit?
Furnish reasons. Because what is happening is,
That
told that in all these courts, matters are pending for long periods of time where you hear elaborately, something like the SLP jurisdiction.
my lord, it should be a
When you
shorter
say
order.
dismissed, that's it.
But my lord, if the High Court start passing shorter orders, your lordships will say, and 136 or 37. My lord,
37 itself.
yes, my lord, please see the section 11 orders which are coming to my lords. They are all 30, 40 pages. Because the High Courts have to write such an order to show that I have conducted, quote unquote, an
Application of mind.
intense yet summary estimate of section 11.
And when the party places a
But
document
we are
of
all-
1,000 pages,
We are all
and
responsible.
then you ask the district judge or the assigned officer, look into those 1,000 pages and record the application of mind. God knows where the application of mind will come
What happened?
in deciphering 1,000 or more pages.
You don't have.
That's the issue.
And then in 37, it's all scope open. If you are not assigning reasons, in 34, 37 is open.
My lord,
And the court has no business except to remit the matter back to the district court.
and then, my lord,
Because now it is not possible.
the other problem is we have only ad hoc arbitration. We don't have institutions, and we don't have, my lord, institutions which we respect. So normally in other jurisdiction, if the institution is respectable, then you look at it and they have also had a look at it, then you don't really want to interfere, you can, my lord. But today we have so many very peculiar awards also. My lord, one has faced them where you know that there is something that is not.
Something we look into 136, who is the judge who has passed the order. But that is not the way it was. That is not an advisable situation. You have to look into the merits, not the author. But we look into.
Now, my lord,
This,
in
one more question.
One
I
more.
just wanted to, when we saw it, let's come to section 35.
35,
The question which we troubled you with,
yes, please.
namely whether its purpose is actually to deal with the aspect of educing evidence.
Right,
There is another aspect.
right.
This is
Yeah.
section 35 one stop here.
My lord, could I address your lordships on 33 and 35 now?
There you can.
So that, my
But
lord,
we just wanted you to
Yes,
read this.
35, yes.
Specific issue,
specifically,
because it's important to the question at hand.
yes.
You just read that.
No instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered or authenticated by any such person or by any public officer, unless such instrument is duly.
So the question is, it actually interdicts to receive, authority to receive evidence, nor shall be acted upon.
Correct.
Now, when section 11, under section 11, now,
Are you acting upon it?
are you acting upon?
Right.
At
No,
least.
At least acting on, Molot, that this is my response, and I'll give it now, Molot, because I can understand that 33 and 35 is certainly bothering my lord. I'll give a response, Molot, not on the larger plane, I'll give a response on the sections. Molot, the section triggers. 35 only triggers if there is a finding that the document is not duly stamped. So, my lord, after the comma, unless such instrument is duly stamped. So, my lord, there has to be first an inquiry as to whether ABC document is duly stamped or not. Or am I making myself clear?
No, the point is, we were actually, stuck up with the concept of admissibility, inadmissibility, flowing from section 35. But we thought that it goes a little further. Section 35.
Or acted upon.
or acted upon.
Yes, my lord, it goes further. No doubt about it. No doubt. My lord, they are two independent limbs.
So then the next
I,
question.
my lord, I am answering the question in a different way.
No, then the next question will be, the theory of unenforceability,
My lord, I
which
am,
you took exception to.
yes.
You said an arbitration agreement is very much enforceable.
My lord, I say it exists.
It exists.
It exists.
No, it exists.
It exists.
But can it be enforced if it cannot be acted upon?
My lord, it
And
enforceable.
when you talk about acted upon,
My lord,
it must be
enforceable at
understood
law.
It should be understood as
My lord,
acted
that
upon
phrase,
in a court of law.
enforceable by law, my lord, is a phrase used in the Contract Act. I'll come back to that, my lord. Please, there's a very interesting, my lord, there is a particular part of Justice Nariman's reasoning which goes on the phrase enforceable at law. So, my lord, I'll come to that. But I have a different answer to 35. I have a very different answer to 35. My lord, 35 will trigger. 35 is a bar. It's a bar, my lord. It's a bar. Subject to exception, my lord. I'm leaving this here. It's a bar, my lord. 35 is preceded by 33. 33 is, in a sense, the same side, other side of the coin. So when the document comes, there is a duty on the judicial authority or the arbitrator to look at the document and make an inquiry. The sequitur is that if the arbitrator or the judge or anybody finds that it is not duly stamped, he can't even act upon it. These are two parts of the same legislation. So, my lord, the bar comes because, my lord, so 35 is the bar and 33, my lord, your lordship, go back to 33.
Let us put it slightly different. When a person, without taking care to get it impounded, without paying up the duty with the penalty, he rushes to an 11th port. He rushes to 11th port with an unstamped or inception.
Unstamped. No, let us say unstamped. Unstamped.
Unstamped. And no doubt about that it is a document, is an instrument.
My lord, that's where the doubt is, my lord. Your lordship says no doubt about it. That is where, my lord, I have.
No, you have yourself said.
My lord, I'm answering myself, my lord. Your lordship.
Because I see yesterday you said an agreement to refer, even if it is a separate independent agreement, has to be stamped. So we begin with an unstamped agreement.
My lord, I go one step.
What you're saying is something different.
The
simple question is, can you
act upon?
Act upon?
My lord, I'll answer.
Will not the court be said to be acting upon?
Right. I'll answer. My lord,
forget about evidence.
Forget about it. Forget about it.
Very act of referring to the
My lord, I have an answer on acting upon it. I'll come to that. But, my lord, I have a preliminary point, which is that please see 33.2. Please see 33.1, 33.2, and then 35. And I'll explain, my lord, why 35 bar is not even reached. No, 35 bar has to be reached. 33.1 says, every person having by law consent of parties authority to receive evidence, every person in charge of public. Now, this is the same language as 35. Except an officer of the police before whom any instrument chargeable in his opinion, which duty is produced or comes to the performance of one, shall. Now, my lord, these are the critical words. If it appears to him that such instrument is not duly stamped. Now, my lord, the examination by the person is to examine whether such instrument is duly stamped or not. That examination is found in, my lord, 2. For that purpose, every such person shall examine every instrument so chargeable and so produced before him in order to do what? In order to ascertain whether it is stamped with a stamp of the value and description required by the law enforced in India when such instrument was executed or first executed. So, my lord, if 33.2 is triggered, then 33 will follow. And if My lord, if I have to conduct this examination, then I will come to a conclusion that it is not duly stamped. And then if it is not duly stamped, it will be barred. So, my lord, the steps are different. We have jumped 3 steps. So, my lord, my submission is that 33(2) examination is not to be done in 11.6. That's the submission. So, if 33(2) examination is not to be done in 11.6, my lord, neither will 33 apply, nor will 35 apply. 33(2) examination is to be done, yes, by the arbitrator. So, my lord, it is not that this is being escaped, but this examination, if you are not required, my lord, therefore I come back to scope of authority. It is not within the Lakshman Rekha or scope of authority to undertake this examination. Because, my lord, if your lordships do undertake this examination, I have confidently today told your lordship, it is arbitration agreement is to be stamped. Till yesterday, my lord, there was a 3-judge bench judgment of this honorable court which said arbitration agreement has not to be stamped. Today, there is a controversy inter parties on what is the value of the stamping, what is the person to be paid, what is the dispute. So, my lord, if 35(2) is to be done by by the 11 court, the bar in 35 will hit me. But 35 bar will not be triggered because 35 will not apply. That's the submission.
Can you not harmoniously interpret 11.6a with section 35 as we are duty bound to do? Both are central enactments.
My lord, 35
No,
was.
are we either we close our eyes completely to 35?
Your lordship is not closing eyes to 35 completely.
We are not.
No, you are only deferring it.
No.
You are not, my lords are not closing eyes to
The
35.
point is that we are bidden to not act upon the document
Unless it is duly stamped.
unless it is duly stamped.
But how-
It is stamped to begin with.
No, my lord.
Duly
It says
stamped is okay.
it is
In a
duly
case-
stamped.
In a case where there is no dispute that the document has to be stamped, number one, we are taking that case alone.
My lord, then we are now going beyond the existence of the agreement.
No, that we are telling you. See, when 11.6a was enacted,
Right.
it was enacted with a particular purpose. What was the legislative history, judicial history, SBP, 7 judges, earlier
My lord, the
judges? They
purpose.
were going into 3 categories of cases. They thought that all of this is covered under section 11.
Right, my lord.
So actually they trimmed the jurisdiction, as it were, and said you have to only look into the existence of an agreement.
Now, my lord, by looking at into the
Now,
existence of
existence of an
existence, my
agreement,
lord.
existence of an agreement,
Right, my lord.
which we have to also bear in mind on in the same breath, we have to also say that it has, we have to act upon it.
My lord, your lordships are assuming that that bar is there of acting upon.
That's right.
I am saying that that bar, my lord, it is like you have not even reached the point. My lord, this 35 will trigger only, my lord, because this expression duly stamped, my lord, has been explained in 214. It is not stamped, unstamped, my lord, it is duly stamped. So, my lord, if it is duly stamped, then there is no bar. It may be in cases, my lord, a document may not require to be stamped at all. I have given an example. So, my lord, the question is, will this court, or not this court, my lord, the 11 court, be required to make that inquiry? Yes, if your lordships feel it is required to make the inquiry, what are the consequences which follow? That is certainly one view, my lord. But having used the word existence, having, my lord, curtailed it from admissibility, validity, existence, my lord, confined. It is confined, my lord. It is a list which has to be ticked off. Is there a valid agreement? My lord, if it is not then the word, meaning of the word, my lord, confined will go.
See, the validity of the agreement, no difficulty.
So, my lord,
You have to not confuse an unstamped agreement with an invalid agreement. It is not. You are right.
right, my lord.
In
So
that sense,
moment it is
not-
valid.
It is not an invalid agreement. It is.
It's a valid agreement, no?
It's a valid agreement.
It's a valid agreement.
No, what you're saying, it is a valid agreement.
It's a valid agreement.
It exists.
It exists.
It exists. It's
Right.
not as if it is void.
It's not void.
Both of that, you're what.
So far, so good.
The question is, when the courts, when section 35, which is equally the mandate of parliament,
My lord, 30.
says that don't act upon it.
Unless stamped.
Unless it is stamped.
My
Unless
lord,
it is
but
stamped.
unless it is stamped is an issue which has to be decided.
In a case where.
My lord,
In a case where.
that's a
nobody has a-
presumption, my lord.
In a case which we are giving us, that all these, because the three judges bench which is referred, it is wrong in saying that an arbitration
So, my
agreement.
lord, that's the issue, my lord.
You know, if it is completely unstamped,
My lord, that
there
is
is
the
no
issue.
dispute about it.
That is, my lord, that is the issue, my lord. The question is, your lordships are therefore assuming that 35 is complied. I am saying you have to look at 35 and you will have to look at 33. I am coming to acted upon, my lord. On the phrase acted upon, my lord, how that works. I'll come to that, my lord. My lord, also your lordships will have to keep in mind, my lord, Stamp Act is 1899 when we had an 1899 Act, my lord. We have progressed considerably with the arbitration. There have been 1899 Arbitration Act was there. Lordships will have to give some interpretation which will make both workable.
Exactly.
Right? Now, my lord, I am suggesting that the only way or the practical way to make both workable is to leave this decision of stamping good, bad, indifferent, high, low, whatever it is, to the arbitral tribunal. Who has the power? There is no dispute he has the power. The sections say so. And he has to obey the law. So, my lord, the other view is, let's test the other view, my lord. The other view will necessarily mean that the legislative, my lord, intention of appointing an arbitrator merely on the existence of an agreement, whether prima facie final or whatever it is, and limiting the scope of the authority will go for a toss. No, that's the reality. That is what had weighed, my lord, with the full bench. And my lord, and it is not our say so, it is the legislative history and the reason for bringing the amendment through. Today, my lord, who is raising this question? Let's put it a different way. Who is raising the question of non-stamping? The person who does not want to go to arbitration. It may be that he has to pay the stamp, but he doesn't want to go to arbitration. So, my lord, or take my lord, case where you want, which we are not concerned with, the interim release, section 9. We are not concerned in this case. Who is raising the non-stamping defense, my lord? And how do we balance it? Do we, my lord, put a chokehold at the stage of 11.6 when 33 and 35 can be equally, my lord, read? My lord, I ask myself a simple question. Is the 11.6 judge required to do 33.2? Is he required to do this or not? If he is required to do this, my lord, this will go against 11.6. If he is not required to do 33.2, then 35 will not even come into the picture.
So according to you, the conundrum is only this. Who is to decide?
That's all, my lord.
Who is to decide? And according to you, the section 33(2) of Stamp Act, that examination need be done only at the stage of first 16 by the arbitrator.
Not at the stage of 16, my lord. Right at the beginning. He doesn't even have to go to 16. He has to do it on virtually.
By the arbitrator only.
Yes, on day one. Because, my lord, moment to have an unstamped agreement, none of the substantive rights can really
So
be
in short, 33(2),
33.
that need be looked into or examined only by the arbitrator.
And that will work well, my lord. It will work in every way. It will work. The revenue will be protected. The document will be impounded. The decision will be there, subject to court control. There will be no delay. Why should, my lord, I put it in a different way. Why should the court burden itself with this headache? Unless your lordships interpret as this is a gun to the head, you have to do it. So, my lord, that's the question. Why should the court burden itself?
Do it completely, complete circle. Because we accept your contention.
Right.
And we also, like prima facie, what to say, is workable. And is a speedy
Right.
disposal of the applications and let the parties come to arbitration. Ultimately, what will happen? From our 11th jurisdiction, it will transfer to the jurisdiction of the arbitrator.
Yes.
Now, obviously in the written statement that will come forward, the first objection would be unstamped or
Yes, yes,
insufficiently stamped.
that will be fought out.
Now they will say you can't proceed, first get an inquiry of 33 to
No difficulty.
and then 35
No
and
problem.
thereafter, meaning thereby, then what we are going to hold and record a finding will be stuck by the arbitrator and then he will take another.
No, Your Lordship will not record a
I-
finding.
No.
Your Lordship will not
No,
record
we are not
anything.
saying. Suppose if we take an inquiry
Yes,
and
ma'am.
record a finding
Right.
in reference 33 to or whatever it is, and say, no, sorry, whatever the document is fully stamped, nothing doing. That chapter is over, let the parties address on merits before the arbitrator. There is one theory.
One theory.
The second theory, as you say, is sorry, you don't intervene in section 11 jurisdiction. Leave it to the arbitrator to examine. All right, we agree with you. Now, the first question would obviously the person who doesn't want to go for arbitration
We'll raise it.
will raise it, definitely.
Lord,
raise it.
three things will happen.
Same man. So,
Aren't we coming to the same conclusion? Is what Your Lordship is saying.
we are on different point. So, when the matter is now instituted before the arbitrator, and the person who is not inclined to go for arbitration,
We'll raise the point.
definitely raise it.
Definitely raise it.
Obviously. Now, the arbitrator will also obtain the exercise. Yes,
He will have to undertake the exercise.
To 33.
Yes, my lord.
To inquiry, and then 35 as to what should be adequate
Penalty,
stamp, or whatever it is.
penalty, stamp,
Now,
whatever.
now, the legislature also says simultaneously that the arbitrator should also conclude
Right, my lord.
within 1 year plus 6 months from service and all.
No difficulty.
Now you will find in the system which we are today privileged, the arbitrator will be stuck to proceed unless that document in reference to which the arbitration proceedings are to commence is not being properly and adequately, insufficiently or sufficiently
Lord,
stamped.
I am doing some arbitrations like that. I'll explain, my lord, what
So,
happens.
so
I've seen that.
what comes to us, subject to what? Are we not to step in or leave it to the arbitrator to
My
take a call and
Let's
do it in his own way?
let's play this out.
Or
Should Your Lordship not decide it?
not decided, right?
So, my lord, let's play this out. Supposing this very point of unstamped is raised before my lords, right? My lord, in practical terms, this, my lord, one is the interpretation of 3335. In practical terms, what has happened, my lord, and I can vouch for this, Delhi is taking a different view. In Bombay, virtually everybody is raising this as the defense. So you file a reply, then you file a rejoinder, then you hear the matter after a year. No, this is the practical reality.
That's correct.
This is one version. So the arbitration is stuck. You've not got an arbitrator yet. The other, my lord, option which I am suggesting, because I am appearing in some such arbitration, where there is no dispute here, my lord, there is no section 11. You straight away go before the arbitrator, the other side has raised the point. My lord, two or three things have happened. One is either the arbitrator has taken the point, you file your reply, I will decide within a week. Right or wrong, I will decide. Whatever I decide either you are liable, he is liable, or I decide it is 10 lakhs or 5 lakhs. That's also a dispute in the arbitration itself, because you can pay and recover, my lord, in the arbitration itself. So one stop, my lord, solution. Secondly, my lord, what happens in some cases, once the arbitration starts, one or other side simply pays it and then adjusts it at the end in the award. Many cases before my lord, one case, the petition has been withdrawn because people have, my lord, because it has been pending, they've simply paid and got along. Like in this case, my lord, they have overpaid according to them. So, my lord, which is the better option? Should this court be required in law or otherwise to decide this? Because, my lord, always the court wants to decide every point, or leave it to the arbitrator where this will be played out at least faster, my lord. And it will come out of the system. It may go back into the system later in 34, but it will come out of the system. My lord, ADR, my lord, we are now speaking of international arbitration, hub of arbitration. If your lordship sees some of those articles, particularly one which is written, the sort of language which is used, my lord, my blood was boiling, but I put it there. My lord, there are, if we overextend or increase the ambit of 11, there is, my lord, an issue much above and beyond. My lord, your lordships are restricted to stamping, but if a constitution bench takes the view that 11 includes, my lord, stamping, then it may legitimately also be argued it may include limitation, it may include X, it may include Y, it may include Z. Where does one draw the line? So, my lord, that is why, my lord, I am advocating the nano mean. And that is why, my lord, I am advocating that 33 and 35 actually does not trigger. My lord, on acting upon, there is a My lord, there is another argument. There are one of the articles, my lord, deals with this acting upon thing, which Mr. Rebello has written an article. My lord, he has dealt with it in some detail in volume 4 on this acting upon aspect. But my lord, my understanding is that this is not an inquiry you should undertake. You should not even say what I am saying, my lord, what I said yesterday, that this is wrong. I had to say it is wrong because the judgment is wrong. No? But it is not something you should be looking towards. You should not be looking towards stamp. It's not your headache at the moment.
Something, it is a jurisdiction for the arbitrator to decide how to proceed. Because the law of evidence is not applicable.
Law of evidence. But my lord, in fairness to this, the arbitrators enjoined by section 35, because he is named as a party by consent. So he will have to look at it. He cannot avoid the substantive law.
No, but the law of evidence is such not applicable.
Law of evidence is not applicable. 19, Lordship is right, law of evidence is not applicable. But he will have to look at it. Well, I'll give an extreme case. Both parties go. The document is unstamped. The arbitrator still has to look at it because it is his duty to protect the revenue. Supposing neither party raises it, it happens. Or if he ignores it and it's taken in evidence under 36, it is waived. It's a curable defect. It's not a big deal, man.
I mean, you're rejecting a disputed case as a premise for your argument.
My lord, I am suggesting all cases are disputed because
Supposing the party who's an applicant under section 11 himself admits, yes, it is unstamped. It really doesn't bear the stamp it should. He admits, he doesn't say, he has absolutely no case. What should the court do under section 11?
my lord, if he admits, then he has to pay the stamp duty. My lord, that is on admission, my lord.
Exactly.
But admission will not make, my lord, the. But then the question is, my lord, should he be at all asked the question?
If he volunteers,
I don't think, my lord, anybody volunteers anything, my lord.
It can
But
be other way around also.
you have to ask the question.
Either to pay tax or.
You say, all right, I volunteer to have a stamp of 20 rupees.
No, the
And
other
then
side,
the other-
other side objects.
Others,
Side
not
objects, and he says, yes, it's correct.
so right. But is the judge required to ask himself this question? Answer, my lord, if he is, 33 and 35 may have some conflict. If he is not, then my lord, that's why it is a very limited jurisdiction. You see agreement, you see, Lord, I'm sorry, the Hindi motor.
Answering the question. If it is unstamped, what kind of 33(2) inquiry is required? If insufficiently stamped, you need inquiry. But if it is not stamped, then what 33(2) inquiry you want?
Well, Lord, I'm saying that
No dispute at all.
Not-
What kind of 33(2) inquiry you are asking for?
I am not asking for the inquiry. I am saying that you please don't get to the 33(2) stage. Your lordship is assuming so many.
oh, but 33 to 35 requires the first point of judicial contact, that judicial officer to see that factor.
My lord, that's the point. In normal cases, yes. In all other cases, yes. The judicial officer, regardless of the parties before him, must see the document and must address his point to stamping. So many cases, my lord, in tax matters we've seen in the High Court, neither party says anything. The judge says it's unstamped. You first cough up the money. But my lord, is that general test to be applied to
With an 11.6.
That's the only question, my lord. Generally, yes. Yes, my lord. Of course, he has to look at it because he's a judicial officer, my lord.
So you are relying on that existence in 11.6.
Confined, my lord, to
To-
examination. My lord, the word used is examination.
So
which is the-
according to you, if in the agreement there's an arbitration clause written, then it is in existence.
It is in
Whether it's
existence
stamped
for
or
the
not.
limited purpose of subject to it being, my lord, patently void. There may be some extreme situations, maybe, my lord, unstamping may come to, but it's not patently void, my lord. Supposing it's absolutely illegal, then your lordships will not appoint. It is not that there is, that is that thin line which has been drawn in Vidyadrolya. The question is, are we expanding the circle? That's the only question, my lord.
So how does Justice Nariman approach it and hold
Let
that?
us show the, my lord, let me now show the three judgments,
Yes.
the four judgments.
Yes.
where according to me, my lord, there is a problem. Let us first see, my lord, Garwari. Only 3 or 4 judgments.
That's it.
That's
Maybe
what,
they will
what
also
there
refer
is
to
to it. And then, my lord, actually, Vidya Drolia, I would beseech your lordships to look at a little carefully, because there are all sorts of things in Vidya Drolia which were perhaps, my lord, not required and are causing, because let me first place Garwari.
Yeah.
Let me first. My lord,
This is Nariman's judgment, which is that.
just Garwari.
Garwar.
Garwari.
Let's see that, because that is what is called its worship finally.
The judgment begins at page 8. Justice Nariman's judgment begins
Yes.
at page 8.
Then straightway we'll go to the discussion of.
My lord, I just want to, if your lordships permit me, since
Yes.
it's a reference judgment,
Yes.
two, three paragraphs, my lord, because I believe it's been put very well. Please come to para 3. At the bottom, page 8, the question is whether 11.6a, which has been introduced by way of arbitration conciliation, has removed the basis of judgment so that the stage at which the instrument was to be impounded, not by the judge hearing the section 11, but by arbitrators appointed under section as is being held by the impugned judgment. My lord, in fact, now thereafter there was a full bench of Bombay High Court which affirmed the view of the High Court, which was overruled. I have put the Bombay High Court judgment also, because that has some interesting passages, my lord, full bench. So, my lord, that. Then, my lord, please come to para 5. Miss Niyati, learned advocate appearing on behalf of respondent, referred us to section so-and-so, 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 in particular, made it clear object of the Amendment Act was to confine the court hearing, section 11, to examination existing, nothing more. She made a distinction between validity and existence. But I am not making this distinction. Argued the provisions are fiscal measure intended merely to get revenue, if at all will go to validity. According to me, Lord, it doesn't even go to validity and not to existence. She relied strongly upon certain judgment, made it clear arbitration agreement independent. So long as it in writing exists in fact, so the whole object of amendment would be defeated, as otherwise a mini trial would be conducted at the section 11 stage. Also relied upon 11.13 of the Act, application has to be disposed on 60 days. Equally, according to her, no prejudice would be caused. Arbitrator was to commence and then impound. Also argued in the present case, appellant has to pay. So, these were the arguments which were made. I adopt some of these, submissions. Thereafter, the Justice Nariman sets out various provisions of the Act, and then from para 8 to 14 is the commentary, my lord, which is in respect of the history of the legislation, which starts at page 14, para 8. Law has, prior to Amendment Act 2515, has a checkered history. And then, my lord, at para 12, he comments.
29, if you don't like.
My lord, may just see 19 to 22 and 29.
Yeah.
And show that, but just 19 to 22, my lord, are very, very relevant. My lord, first, before that, my lord, I would ask your lordship to see para 18, because I believe, my lord, this is where one error has crept in. 18 is para page 22. It will be noticed from the aforesaid judgment when arbitration clause contained in arbitration or conveys different consequences ensure depending on whether agreement conference is registered. It is settled. It is settled by SBP and Company that section 60 of the 1996 Act has full play only after the arbitral tribunal is constituted without intervention of the court under 11. My lord, this was the old view. This is one, my lord, problem with this judgment, that we have this going back to the old view. And on this basis, the 3-judge bench, my lord, at page 2, page 24, rejects the contention in view of the law laid down by the 7-judge bench, difficult to accede to the argument made by learned counsel on behalf of respondent. Section 16 makes it clear arbitration agreement independent existence must be applied by delay. No, I would respectfully submit.
After that. Will be 10 minutes, I have a meeting. So About 10, 15 minutes, 2:15 you can come.
Malad, there is some other.
That's right. After that only, because
Very-
we'll have to do that.
very-
We're just telling you we're there, we'll come 10 minutes.
No,
We have to-
Deep, you're
meeting
right.
is there.
Deep, you're right.
Let them make it clear. Which one you'll take first?
Yes, let me begin with a caveat. The present proceedings fall within a very narrow compass. Already,
Correct,
yes,
correct.
already there is a direction and everything has been laid down. Whatever the practical difficulties this one vacuum is to fill up.
Narrow
Only
is-
to, yes,
That is a narrow.
That's-
no
that's
question
all
of any
because-
further hearing
yes,
on that.
yes,
We will simply, make it a little bit more workable.
correct.
We can't be, reviewing it. That's
Yes,
not
exactly,
possible.
exactly.
Now, my lord, what are your suggestions? Just
Yes.
tell us.
Lord, what I've done is, as per your lordship's direction, I've taken para 198
Ah,
and I made a chart. And where is unworkable, we have put it in red. What is the, so there are two
so
things.
that what is the provision to be substituted, that's all.
Yes, yes. So the changes
There's
are.
no need for any discussion, order and all that. We go.
So what what we have done last time.
We'll dictate the matter in court, open court. There is nothing to be reserved or anything.
Yes, yes.
We can't, there is nothing to be, can't be reopening the whole.
No, no, no. no problem. At least make it workable, that's all.
So,
And only one thing in the judgment earlier, apart from the majority judgment, there are concurring views of this Chandrachud and this CP. Some 2-3 passages where the court has taken the trouble of defining what's a terminal condition, because they are concurring views. That will also be the views of the court. So if your lordship can see that also after I finish this. Now,
we can't be interfering. All this.
one 198.1, but this is a chart in landscape where the second column contains what is the original guideline as per this earlier Supreme Court judgment. Now, in reading, I have put what act to make it more workable. But this is a landscape, or this is Rastogi, we see this, it's in landscape
Why
format.
this one?
No, there are two things. What we have done is, I'll explain you. One is suggested modifications which are in track, which is in a vertical format. Lordship will just see this what I'm seeing now. And has the Lordship got the landscape format? Horizontal format?
It's a great.
Yes, yes. That is the final thing. I'm in 3 stages. One is the suggested changes post directive. Then one is in track, I have given what are the portions to be cut out. And here, my lord, I have given the suggested modification. May I read it? Only the reading portion not supposed to see me.
Dr. Banerjee and Banerjee can. How long? Because we don't want to keep Gaurav Banerjee and
Definitely it'll take 30 minutes.
30 minutes.
Yeah, so I think
So your matter will come tomorrow. That's all. We don't want to keep you waiting. The rest of the matters will come.
since the Lordship is going to dictate also.
We'll try to,
Yes.
close it. Otherwise, we'll dictate tomorrow. There's no keeping, no question of reserving it.
No.
Are we discharging Mr. Banerjee even if he's interested to listen to Mr. Datta?
I'm sure someone will never stand.
Always a privilege to listen to Mr. Datta.
But I'm also discussing that arbitration point with him. So very interesting.
Mr. Banerjee, how much time you are supposed to take now? Mr. Banerjee,
Well, Lord,
how much time you are taking?
I have 3 judgments left, the 3 reference judgments.
So that tomorrow we can
And
conclude.
yes, my Lord, and I will also address 2 questions of your lordships. One on the 1940 Act, what was the position? And second, my Lord, that 33, 35, etc. That's all there is.
Half an hour maybe, like we can just time management so that,
My Lord, those 3 judgments may take longer, my Lord. I, in all honesty, my Lord, your lordships may. But I've taken only 2 sessions, my Lord.
No, we don't.
Yes. So, my lord, so Lordship will see whatever is suggested. If the Lordship approves it, then that will be modified. If Lordship doesn't approve it, it goes.
That's right.
Yes.
Simple.
Now, Lordship will kindly see,
Yes.
we have, as far as the first is concerned,
Yeah.
it shall be in writing clearly stating. May I read the second column with the modification so that will be easy, my lord, what is been added.
This is 1.4, is it?
Lord, 198.1.4 are the conclusions,
All
the
right.
guidelines. Lordship directed me yesterday that
You're right, you're
yeah,
right.
just make the changes and suggest it because we are not in review. It's not a larger bench.
Absolutely, absolutely. It shall be in writing clearly stated.
Please read the suggested modification. We'll go to that. So reading 2 columns in reading. Or may carry a greater possibility of harm than reasonable benefit and may thereby cause him pain anguish. Why that is necessary is because the Indian Council of Medical Research published the definition of term so and so. This defines potentially inappropriate treatment or interventions aimed at cure carrying far greater possibilities of harm. I'll give you lots of an example. You know, there's an elderly lady, I'm giving true life example to you. Elderly lady of 1993. She's perfectly in good health. She's carrying on a normal functions, barring slow motion, is movement is slow, etc. She has a cerebral stroke. Yeah, she's admitted to hospital. Now, technically, the clot can be removed by a brain surgery, but you'll have to open the cranium and operate open brain surgery. The doctors advise that, look, at her age, it is not advisable to have such invasive surgery where you're going to break open, cut open the brain and do it. The possibility of her sustaining the surgery, she may get surgical shock, will not survive, or even if survive, you don't know what will be the further complication. So that is a case where she's not terminally ill, she's not in a vegetative state.
So she is conscious.
No, she's not conscious.
Okay.
After cerebral stroke, yeah, I mean the exact example of that I'm personally known to the doctor.
That's right.
So, and this has happened in so many families, Manoj.
Well, that's what we are telling you. If she is conscious, she is able to take a decision independently.
Yes.
You don't need this.
You don't need this.
That's what I-
No, so what I'm saying
The
is,
important thing
Correct,
is
correct.
that she should have.
Lordship rightly pointed out, all these are cases where the person has reached a stage where she cannot take this thing. And that's why this Chandrachud puts the thing of what is called the subjective standard test. That is to say, when the man was conscious, he said that in circumstances A, B, C, D, please don't put me to this. Now he's in a coma. Now he's in a position where he can't decide. So the court says, respecting, because privacy includes personal autonomy, respecting the autonomy of the individual. When he was in conscious state, he chose that I don't want this. So when he's not in a conscious state, please respect his wishes and follow the advance directive. Therefore, I just wanted to add this, that there could be a situation where what the ICMR calls futility of treatment. The treatment is technically possible, but may not be worth treating like an elderly patient. And this has happened in more than one case. Another case I know, the person had a stroke. They said instead of opening the brain, you have to cut open this vein and put some stents here. Again, the person was 92 years old. Then the doctors at Madras said, look, it technically is possible, but we won't advise it because the patient may not take the strain of the surgery and it may not, we don't know what benefit it will get after this. Quality of life may not be there after
So
that.
who would do it then?
No, I'm saying,
If the patient is unconscious.
so these patients would have made an advance directive.
No, who would have done that?
What?
This particular treatment, at whose instance would it be done?
The relatives, the children?
So what would they be doing that for?
No, the point is this.
They're just telling you.
Yes, they will be relieved of the burden of taking a call. Some people will say, let us take the chance. Why? Suppose the person is 75 years old.
Are we then proceeding on so many presumptions?
That's why
That
the
there will
general.
be somebody who is not, will have to take a decision, he'll be put in a dilemma, and therefore let us put a.
Yes, but that's the whole logic of advance directive, that the point is, the person makes a choice when he's conscious. That's the logical judgment of, the concurring judgments of this, they go into all this more elaborately, discuss the thing. So what we're saying is, we don't want to restrict it to terminally ill, PBS, and this. So we just put it generally, if your lordship approves,
Yeah.
or may carry a greater possibility of harm than reasonable possibility of benefit, and may thereby cause him pain, anguish, suffering, and further putting. So all that we're adding is, may carry a greater possibility of harm than reasonable possibility of benefit. So it's a weighing this.
And in fact, in this, we will tell you,
Yes.
some of the amendments to Income Tax Act, which have brought in its strain greater complexity, engendered more litigation. We perhaps think, with all due respect to you, that these words.
I'm not complaining, Guru.
Yes,
I'm not complaining.
all due respect to that, or may carry greater possibility of harm than reasonable policy. This itself will become a matter of long debate.
No. This, you're watching the last column. This is not my phrase. The Indian Council of Medical Research, on the basis of consensus received,
That is the guideline kind of.
now accepted by the medical fraternity. This is not a suggestion by me.
Is this the problem which is brought you to this court? The fact that this is actually being kind of a spokes in the wheel kind of situation.
No, we are envisaging what are the end of life situations.
That's right. I'm saying,
Yes.
why you came with an MA is some reason.
Yes.
Is this the reason?
Yes.
Because otherwise we are creating a new second.
No.
What we thought was, will it not work with the existing guideline? As far as possible, let us not.
No, I agree. This will.
So let us read that existing guideline once more.
Yes.
Shall be in writing clearly stating as to when medical treatment may be withdrawn or no specific medical treatment shall be given, which will only have which means what are the medical treatments withdrawn and the treatment which will only have the effect of delaying the process of death that may otherwise cause him or her pain, anguish, suffering.
Yeah.
It covers.
That covers everything virtually.
No, Mr. Datar, the red line part,
Yes,
uh, are we clear in our understanding
Yes.
that since it is coming from the research done by the ICMR and inputs put in, a medical professional will be in a position to understand what it means?
yes. And this is
Is
where
that what
medical
you're trying to
treatment,
say?
Your Lordship, absolutely right. This italicized red link portion should be read as medical treatment. What is the medical treatment? If the medical treatment is going to have a greater possibility of harm, then reasonable possibility of benefit, all in the realm of probabilities. This 90-year-old patient may very well survive.
That's
brain
right.
surgery.
So can we say that all the medical treatment, once again use the word medical treatment there,
Yes.
instead
Or-
of,
Or the medical treatment may carry.
I mean, so that you put
I'm
a
saying
little
no, no,
clarity.
nothing is lost. It makes
No.
it more workable. That's my humble submission. I agree, Your Lordship.
So therefore, the medical fraternity must understand that
Yes.
this is what it means.
Yes, that's why the last column. Yes, Lord.
It should not be
Yes.
innovation of the court or Mr. Datar or Mr. Natarajan.
But I will just clarify. what
Particular
Mr.
thing
Vice
it is-
suggested. Nothing is from our own suggestion. We have discussed with doctors and there is a complete report of the ICMR which is introduced. included
It's
in our-
capable, this is capable of getting misused. I think it's much wider the expression is given. May not be scope of review, may not be scope of these particular proceedings. Already everything has been laid down.
Robert, Lord, I'm
You have to
suggesting, I
see
don't
the, only
agree.
the practical difficulties.
Lord, we spoke to doctors in the evening. They said, please add this from ICMR. You don't want to add it, leave it. I'm not a big quarrel. I'm saying it makes it much easier because there's a medical treatment which has every treatment as a benefit, as a possible harm. So the doctors take a call that in a 92-year-old lady who's had a stroke, who's otherwise not terminal, is completely normal, but now she's not conscious. The possibility of benefit is much less than the possibility of harm causing to her. That's what I'm suggesting. So I don't think anything wrong in including it.
And, like a tenant landlord comparative hardship theory.
Yeah. No, it's not a big issue, Your Lordship. I personally feel nothing is lost by adding it. I leave it to Your Lordship.
What is your view?
That's right. It will open up everything.
How-
I don't think it is not in a matter in which the application for this one, the correction or practical difficulties are brought.
What is
It can be examined.
I don't think it's necessary.
Let me say it out aloud, respond to my brother judge. Suppose the element of misuse is left out of our consideration, then this is a harmless thing otherwise, in my, as I look at it. But when we examine it in the context of a possible misuse, then maybe something else will come in.
Unless you've got a primary board, misuse is taken up by the primary board. Who takes the call? Who takes the call?
See, we should protect the doctor against the potential litigation
That's why I'm saying.
by the, say, next of kin of the.
Lord, that is exactly the reason why, my Lord, I'm grateful.
No, one another aspect, a clarification cannot lead to
Review.
more confusion.
My Lord, we are pointing, we are trying to solve the problem, my Lord. If we are going to say that we can't add a word or sentence, then it's a different issue altogether. We have met doctors, why we have taken so much of trouble and spent so many hours is that doctors are finding it practically. Please think of the I'm humbly requesting, think of the medical fraternity and think of the patients. Lord, my own friend has gone to Bombay, the magistrate says come at 3 o'clock, come at 4 o'clock, I'm not ready today, I don't have a, that's why I'm saying.
That's a different
Yeah.
matter altogether.
So I'm just suggesting, why I'm saying.
All right, we will just, I will consider.
Yes, I'm just saying, my point is,
We have taken note of it.
I-
Next point.
Lord, may I just say something? If it is altering the structure of the earlier thing, then don't accept it. If it is only clarifying or helping
We
it,
understand that. Next one.
next.
I
They
mean,
may clearly indicate the decision rate circumstances. Your Lordship pointed out that this is not very clear. So we just added this for your Lordship's suggestion. It should clearly indicate that life-sustaining treatment may be withheld or withdrawn if the treating team of the executor determines that it is potentially inappropriate at a time when the executor becomes a patient and loses decision-making capacity in relation to administration of treatment.
Be kept.
this can be.
Very good. Next one.
We will be very clear then.
Yes. Now, Lord, this para 198, in fact, this is very important. 198, which is Ravi Kumar also mentioned, that is the most, that recording is the important. The document should be signed by the executor in the presence of two attesting witnesses, preferably independent, and countersigned with the judicial magistrate. We have put attested before a notary as defined in section 2D of the Notaries Act, read with section 11 of the Act. But this suggestion was made in the earlier judgment also, but they didn't incorporate that notary. I thought notary is enough, good enough because
Are you very comfortable with the notarial process?
at least it attested before somebody, madam. Attested before somebody.
Instruction from the government, and so far as this clause is concerned, it can go before any gazetted officer. That would be more
That's what we said. Whether gazetted officer means there are a number of gazetted officers.
notified gazetted officer. That can be done.
No, that's what he's saying. There are a number of.
Any notified?
Any
But
notified.
I remember when Gazette is a nightmare going because officer will, we will know some class 1 officer,
Yeah,
you know,
yeah.
go to him, he'll say, come in the night. The notary is the best, but in most courts, the notary is
City stroke and gazetted officer.
yes.
That can be.
Yes, because what happens in most courts, notary publics as there, sitting there, you know. You can go there and get it done.
Stroke would be.
At least they'll get some.
I didn't think of that. So there'll be some sanctity, but let's say it has been signed before a notary public.
What do you say to this?
We have lost the
Notary or gazetted officer, that would be better. That's what the. Because,
Let it be in the alternative.
yes, that's right. That's right.
We have lost the sanctity of notary now.
Yes.
Notary can come to your residence and put the stamp without the paper being signed.
No, but there are many people who, though there are notaries also, as in everywhere there is, like medical certificate also, some doctors will give, some doctors will not give.
We have lost the whole sanctity.
So this we make it, subject to what we have said. Notary stroke
Or
Notified gazetted officer.
gazetted officer.
notified gazetted.
Because in government itself has eliminated gazetted officer in many things.
Yes.
Today, yes.
No, from every.
Everything. I remember earlier you have to
Yes,
go and
yes,
contact
yes.
some IS officer, if they come in the evening, go and get it signed.
As a lawyer, every second man will come to you, take my documents to some vessel officer and get it.
In addition to this.
Good, the government has
I eliminated gazetted officer.
not required. Huh?
In addition to judicial magistrate.
Gazetted officer.
It makes it more workable. We are trying to look at,
Right, we make it workable because suppose the person is not able to move, suppose the person is wheelchair bound, mentally conscious. Now for her to go to the notary public may be a problem. Mr. Nataraj may be right. At least we can request the gazette officer. If he's a known person, he can at least come home and.
Now you have used the word to attesting witnesses, eh?
Yes.
The attestation has a particular meaning.
Two witnesses?
No, no, witnesses, not mere witnesses.
Yes.
Attesting witnesses, it has been defined, as you know.
Yes, yes.
in the Evidence Act.
Yes.
The Transfer Property Act Evidence Act.
Yes.
There's a difference between an ordinary witness and an attesting witness. You know that?
Yes, yes. The person attests to the signature.
Animals
Yes.
should be there.
Yes.
And then you should see it, etc. Okay, that is already there.
It's already there. And why the Lordship is right, suppose, both the Lordship said, what about the misuse? At least if a matter goes to court, they can say, I was the attesting witness, I saw the person signing.
That's right.
Next person.
So this is a notary under or a gazetted officer.
Yes.
In addition to here.
So the poor
No,
man.
Lordship, please, my humble prayer is no JFMC. Folded hands and requesting, don't put JFMC. That is the biggest hurdle for this thing to work.
In addition to.
Says JFMC in Bangalore.
In fact, it will be troubling the magistrate also. Maybe having so many.
No, I'm sorry, I got a WhatsApp received from a lawyer in Bangalore about this going to JFMC. Now, they say, is he going to attest on the judicial side or the administrative side? I got a whole message. What the Bangalore court says, you file a criminal petition. Then the section is saying you're filing a petition, where's the pending matter? Is it an application? Then what happens, I'm told now with all the digital thing, once you make a criminal application, the petition on the criminal matter, it is picked up. So when you go for passport or anything, there's a record that you have applied to the criminal court for some clarification. I got a WhatsApp message from a lawyer in Bangalore. He sent me at night. So let's leave the JFMC, my humble request.
My brother is concerned about review, modification, whether we are exceeding jurisdiction. That is what.
No, but see, Lord,
concerned
the
about.
point is, suppose the Lordship records that this particular passage is creating problem. Nothing wrong with modifying it, humble submission. Lord, we modify matters so often. Rate of interest is modified. This is modified.
So from the word and countersign, that will be replaced by what you have given,
Yes,
isn't it?
yes.
Then what else is there?
Sorry, Lord, and one more thing in JM Farsi, The magistrate says, unless I get a direction from my chief justice that you are entitled to do so, this is not part of my job. That's another problem they face.
That
Because-
can be sorted out by.
No, I'm saying why you just, if we can avoid
It
it.
may not be because he is designated for that purpose by the district judge, going by the.
Well, I'll leave it a lot, Lord. That's my biggest request, Lord.
But of course, this practical difficulty that is there. The other question will not, because designated by the district judge. For what purpose? For this purpose.
That's what I
So the other question may not have.
Then he says you must file an application,
That,
a criminal petition.
that, the other question may not.
I'll let you. No, then not, then once this magistrate goes, not the other paragraphs go. And just for your lordship's consideration, I've given a separate,
Which paragraph goes?
paras 198, 3.3.3, 3.4, they go. Because all are JFMC.
No. So in place of JFMC, the notary public stroke gazetted officer will come.
No, that's coming in 198.3.2.
That's right. We're talking about that.
Yes. No, that I'm now come to 198.3.3.
No, we are concerned about and the notary. Okay, you have put notary, we are putting gazetted officer also.
Yes, your lordship is right. That will automatically fall.
He says as a consequence of that, 198.3.3
No,
and
no,
3.4
just
go.
be notary and gazetted.
Yes, that's, as a consequence of that,
Notary or
3.3 and
gazetted officer.
3.4 will go. That's what he says.
This can be done.
Yes.
Lordship is said notary or gazetted as the case may be.
That's right. As the case may be, that's enough. Anything else?
Then please come to 198.3.5. The JMC shall cause to inform the immediate family members.
Mr. Datar,
Yes.
point 3, digital format, keeping in digital format, can't be shipped to something else. Why to delete it?
Yeah, sorry, my friend has got whatever.
So then
Yes.
again, we have deleted, you're deleting everything, huh?
Yeah, no, one in 198.3.6. Lord, please come to 198.3.6. I'm answering that point in 198.3.6. I just finished this, Lord. I'll just come. Lord. Just
That's right.
Just bear with me for a minute. Just please bear with me. I'll finish this. The executor shall inform and hand over a copy of the advance directive to the surrogate decision makers named in the directive, as well as to the family physician, if any. So instead of putting immediate family members, we put surrogate decision maker, which is a term used by the concurring judgment of the.
Family physician has disappeared.
It is there, as well as family physician.
It's there,
Yes.
but in real terms, it's
Today, very difficult to get a general physician. Very difficult. Everybody is a specialist. If any.
You have said the witnesses and the jurisdictional JFMC, I'm reading 98.3.2.
Okay.
Shall record their satisfaction that the document has been executed voluntarily, etc., etc. Now, where do they record it actually?
In the same document itself, in the same advanced directive, they will record.
This document, because it doesn't require to be stamped and all that.
No.
We proceed on the basis.
Yes.
It doesn't have to be
No,
stamped,
no.
number one. So it'll be on one white sheet of paper we take it. It'll be typed or written or whatever. So overleave or on wherever there is.
At the end of the document, there'll be attesting witness 1, attesting witness 2, and there'll be notary public. So they will say, or the gazetted officer, they will say that this advance directive has been signed in our presence, and the person and Mr. So-and-so
Full
was
understanding.
full understanding. Because that's the Supreme Court language, we could not.
So we can't change that.
Yeah.
Let it remain. So that let it remain. So 198, 3.2 will remain.
Where is this?
3.2 will remain. Let us keep it like that. That is not complicated.
But just let's see this format.
No, let's not see. It's there.
Well, Lordship mentioned we have got 5 copies. So since that's the attestation is important.
Then the next is 98.3.3.
Yes.
You have said the JFMC shall preserve one copy of the document in his office that you are going to delete it.
No, I'm going to make a change in 198.3.6. What this is, Rastogi asked about digital format. We have got one suggestion.
No, what you're saying is what is to happen to 198.3.2.
This has to be deleted because the JMC is not there.
There what you're suggesting is
Ah.
that because it will be now done before the notary or the gazetted officer. Now, if it is done by the notary, let him keep a copy at least in his office because he'll have an additional copy.
Okay. Please see 198.3.6, then we'll come to it.
Because otherwise, what will happen? Who will where?
No, like a will, not who keeps a copy of the will.
At least a copy should be there, so it can be counter checked.
Digital format.
Six.
A copy shall be handed over to the competent officer of the local
No,
government.
second one, the executor may choose.
As to incorporate one in their existing electronic health records, if any. Isn't meant to do that.
So there's 198, we'll say,
I'm told that there's a national, please inform the court. She's done a lot of work on this.
No, Your Lordships, there is the National Digital Health Mission under which there is, an initiative are being undertaken to ensure that all hospitals have interoperable electronic health records. So if I go to a hospital and I sign in voluntarily with my unique health ID, that hospital will have access to all my patient records, all my past histories, including from other hospitals, and this will be available to another hospital should I transfer there at some point. So what we've suggested is that the most important thing is for this directive to be available to doctors. So once it has been executed, the executor may choose to incorporate it and integrate it with their patient records, so that this then automatically becomes part of the patient records and shows up when you take admission to hospital.
wherever, whichever
Exactly.
hospital he may be,
Exactly, and this is voluntary, so there's no compulsion.
no
on
right
the
to
executor
privacy.
to do this. And the NDHM has now privacy standards for all
So
electronic.
where have you
health records.
incorporated that?
So this is under 198.3.6 is what we've suggested.
Is that a government initiative, this particular portal,
Yes, yes.
integrating all the medical records? It's a government initiative.
It's a government initiative. And there are published standards on privacy.
Privacy also.
Or she may say, records if any, as mandated by the National Digital Health Mission.
So let me read that time, 198.3.6, is it?
Yes,
You have added there?
yes, the next page, page 4.
So we have not completed about this 198.3.5.
No, what happened was, I Lord Justice Rastogi asked, who will record it, any digital data? So I said the digital data part is coming in 198.3.6. That's why we jumped to
What
198.
about 198?
We can go back, we can go back.
No, it is there, 198.3.5.
Yes. So there, and hand over a copy of to the surrogate decision maker named in the directive, as well as to the family physician, if any. Then the next paragraph is on digital.
What is this? What is it? Shall inform and advance?
No, because the Supreme Court said that the magistrate should inform the immediate family members, so that information that so-and-so has signed.
So the executor in place
Yes.
of the FMC.
Yes. So it's not that, at least the family members know that Mr. X has made the advance directive.
Correct. So that will be, now you are replacing it.
Yes, no, what I'm saying is, instead of putting immediate family members of the executor, I have put advance to the surrogate decision maker named in the directive, as well as to the family physician, because advance directive will say, advance requires there should be a surrogate decision maker, like an executor in a will. So I must tell the executor, suppose,
What do we die? No, if you say this, if you put it, confine it, that man die, becomes incapable of acting otherwise. He becomes himself a paralytic.
He gives, no, I'm not doing.
There
Why do you
will be
create-
multiple surrogates.
Huh?
You can list multiple surrogates.
but when you do a will, we put a person who's younger also in. on the-
Why don't you put family members? I mean, normally, when there's a
Tell me.
post-date donation of body,
Yes,
the
absolutely.
family members only inform.
This is because this is the court's own requirement on what an advanced medical directive must.
When the
contain.
court's a family member, why do you make it surrogate?
No, your lordships in.
198.5 immediate family members.
There is it in the previous paragraph.
This we should keep thinking. No, see, 198.3.5, it says JFMC shall immediately inform the immediate family members
You're
of
right.
the executor.
If I may just take you to 198.2.5.
We're talking about 198.3.5.
No,
What
that's
my
the
friend
point
is
I'm making, your lordship, so that the court has.
Not get too much.
No, no.
We are, I think.
No. What I'm saying is we have only reproduced the paragraph which are going to be changed. 198.2 is not being changed. At page 130 of the judgment, your lordship takes the book.
We have reason to hear 198.3.5.
No, what my friend is saying is, the surrogate decision maker comes from your lordship judgment in 198.2. And lordship said only point out the changes, don't touch other things. So we have only highlighted it, your lordship just takes page 130. It
Or
should
close relative.
or guardian or close relative who in the event of executor being incapable of taking decision in the relevant time will be authorized to give consent or refuse or withdraw. Not in the concurring judgment of Justice Sikri and Justice Chandra, they use the word surrogate decision. Or can we do one thing, Lord? Lord, can I suggest one thing? In
What
this,
will happen? We are just asking you this question.
no, I'm just suggesting one thing.
Supposing this person whom you name,
He dies, yeah.
he died, what will happen?
No, can
The
I
whole
do
thing
one?
will break down, huh?
Yeah. No, Lordship will.
And he goes into
I
a
appreciate.
Alternate.
Appreciate. What I'm now thinking is marrying 198.2.5 into this. What we can do now is executor shall inform, as Justice Bose suggested, we'll borrow this language of 198.2.5. The executor shall inform and hand over a copy of the thing to his close relative and to his family members / close relative. Suppose he's alone. He has no family. Family members / close relative, who in the event of the executor being incapable of taking a decision relevant time will be authorized to give consent.
Even then, this is a defective thing for as it stands because
If the person
think
dies.
of, supposing the guardian or the close relative die, what will happen then?
Then we'll have to add a paragraph.
What will happen then? And he goes into a limbo. I mean, he goes into
I know.
a coma. What will you do then?
Provided guidelines for where a person loses decision-making capacity.
No. Then Lordship may add a paragraph that if the surrogate decision maker or so and so dies, then the advance relative will not be inoperative merely because the surrogate decision maker has died. That's all. We can't provide for every eventuality. That's also a problem. That's why you've got income from other sources because we can't prescribe all this. Can I suggest one thing, my Lord? In 198 can do one thing. We can say that.
That is why we said that in the name of clarification, we cannot.
I understand. Now, my Lord, what I'm submitting is
One suggestion we are just telling you,
Ah.
subject to what you might say. It should specify the name of a guardian or a close relative is what is mentioned.
Hmm.
You can perhaps say it in the plural so that it will work.
okay. And whoever is that, somebody will be alive.
Whoever is there,
Appreciate. Perfect.
this is what we can think of.
No, it'll make it workable, bro. So that we don't have a situation where they'll say this person has died, who can take it now?
When we
Somebody
thought
will be there.
Can be.
Somebody.
Yes,
Somebody will be there. Lord.
somebody will be there. Na?
Yes. So what we'll do is, shall,
So we, this can be, you have not suggested.
Or
we have
else order 5 rule 20.
guardian
can I put like, bro? Can you see?
or close.
Can Lordship, I'm suggesting cut off to the surrogate decision makers.
No, what we'll do is 198.2.5, we will add just one S to guardian, making it plural, close relative S. Correct?
But it should be, are they named in the directive?
Uh,
They should be named in the directive.
that's what you're saying.
Correct.
It shall, see, but just,
Your 198.2 will be added with the plural.
that's all.
That's all.
Yeah, just we'll read it out to you.
Yes.
You should specify the name of, instead of a guardian,
Guardian.
say guardians or close relatives to protect him, because even if he says only one, where this contingency occurs, he'll be protected.
Can Lordship say, sir, guardians, can Lordship put any guardian or close relatives?
The name of any guardian
Or close relatives.
Ideally, the person making this declaration, he should inform everyone.
That's what the Lordship.
naming the person who can give the consent. So we'll make it, it should specify the name of any guardian or any close relative.
I'm just.
But again, it will be plural. Again,
Suppose I
it will be
make it
singular.
tomorrow, suppose we make it. Typically, I'll mention my wife or my son or my daughter.
Yes.
Yes, because they'll be the normally people who will be involved in, suppose something happens to the patient. Generally, immediate family will be involved.
That's right. So, I mean, because.
Your Lordship is right. We'll close it, we'll delete this. We'll borrow 198.2.5.
So, no, 198.2.5 will remain as it is. I mean, except for adding this.
This will be repeated here.
uh,
It will be repeated here.
198.25, it will be the name of guardians. I think it should be guardians
All right.
or close relatives. Otherwise, again, it will be singular.
Okay.
Any. So we put it any name of guardians, any will go, or close relatives will take over and would be authorized to consent the auditor. Then it remains perfect.
Yes.
Then you come to 198.3.6.
Yes. But I'm requesting in the light of what Ms. Mehta has pointed out, records, if any, you can say that these records shall be, these are electronic records as prescribed by the National Digital Health Commission. That can be added. So it can't be any private record. It has to be only the, it can't be record of say Apollo Hospital or this hospital. It has to be the records as mandated by the National-
Which clause?
198.3.6.
We have to first finish that 198.3.5.
Oh, I see. That you have
given
Lordship
suggestion.
just now finished.
Huh?
198.3.5,
Ah.
the lordship is striking off this, the entire surrogate and putting 198.2.5 again.
Modification.
So immediate,
With
family-
any
Yes,
and
that is immediate family member.
No, 198.2.5 is, it should specify the names of guardians. Now it's only specifying the names. 198.2 is what the document should contain.
What should be done is,
Yes.
the GF is 198.3.5, because we have added guardians and close relatives
Hmm.
who are named.
Hmm.
First of all, they should come to know.
Yes, yes,
Most important.
correct.
So
No, but
they should be
be
informed.
informed,
They
correct.
should be, so we'll have to say shall cause to inform the guardian
Guardians
or close guardians or close relatives
who are mentioned in the advance directive,
who are mentioned in the,
advance directive.
isn't it?
Yeah, exactly.
They should know.
They should.
They are the ones who have to do it.
Correct. Because
Then the other thing can be, and other family members also. I mean, that also can be.
so 198.2 is preparing the document, 198.3 is
But there
informing the
again,
people.
we are knocking out the JFMC. Eh?
Yes, completely.
You're putting that responsibility on the executor.
Yes, yes, because nowhere in the world your court is involved. Guardian Act defines who's a guardian.
But if the person concerned is not a Hindu,
No, I'm just defining. Oh God. That's why I put guardians of close relative. Irrespective of religion, we all have relatives. So you don't have to worry whether it'll be religion neutral.
So here we are just, making it to you.
Yes.
Uh,
Executive shall inform.
198.3.5, we are making it the executor
Shall inform.
cause it to inform.
Yes.
Cause it to inform. Shall cause it to inform let this immediate family members also know.
Hmm.
Plus, we will add the guardian, because he need not be
You
the,
can also say the guardians, close relatives, and immediate family members.
yeah.
Actually, they'll be repetitive because immediate family members are close relatives in any case.
They'll anyway know. That we are not, they are not changing that.
All right.
the district judge.
To the,
what about in the case of an orphan? Can we say that he is not having an right at all? Whether in that case it is JFM? Because we cannot say that no, he will not be having just because he is not having any close relative. or
You
guardian.
can't deal with every possible eventuality.
We are only this
Correct.
this right.
No. See, the point is, as far as an orphan is concerned, once he becomes an adult and once he becomes a major, I'm just sticking to that. An orphan as a child, right? Now, the orphan becomes old, he starts working, he marries, he has a family. Then he
Not
becomes an adult.
suppose that is why.
No, I'm saying if it's an orphan and if he remains unmarried, remain anything else, then yes. Then he'll have to put a surrogate decision maker.
Suppose he's a chronic bachelor or a spinster.
Correct, but he'll have a friend, he can say, my friend. My chronic bachelor.
so we're just reading out what we have done. 198.3.5 will read the,
Not one proper, I should mention orphan on a sideline. What is the caste of the orphan? I'm having a problem in Madras. He gets no benefit. Anyway, that's a different issue.
so that we are just adding it, 198.3.
Yes, I'm having this problem right now. but anyway.
The executor, just
Hmm.
listen, the executor shall cause to inform the guardians or close relatives referred to in paragraph 198.2.5.
Okay.
And the immediate family members of the executor, if not present, that all will be made. What do you say?
Yes.
The guardians slash close relatives slash immediate family member. But the point is, the whole purpose is they should know about it. That's how they know, that's all.
They will know about it, they'll take in, but then once a close relative mentioned in paragraph 198.2.5 are brought in, and the other immediate family members, is it necessary then?
According to me, no. It's a surplus age. It's a surplus.
Because he would anyway tell.
But just keep it what it is.
Normally, he will not tell his wife.
It is the purpose.
He will not tell his wife because wife will say, okay.
By putting it in plural, does it mean that it should be informed to everyone?
Yes.
No, only to the persons mentioned, the family members, etc., who are mentioned in 198.2, because they are to be named by him anyway.
Only named persons will.
The attesting witness need not be from them. So that this is why this will sort of give it clarity.
Very well.
So the other family members will not be then necessary.
Correct.
Yes.
Correct.
Then it'll be guardians / close relatives.
Correct.
To the extent that is what
Yeah,
I.
that's right. To the extent it's not.
And the immediate family members.
Tell us one thing. What's coming?
Then may I suggest also reading
Brother
original.
Jaji, who has authored, how much time was spent
That's
to
what I'm
find
saying.
out
And we are
that laying down the final modalities.
So let the family members also remain.
Then can I do one thing? Can I say something? Put guardians / close relatives. Forget immediate family members. Close relatives are immediate family members. Close relative itself means immediate family members. Who are my close relatives? My wife, children, etc.
No. The person who
Who are mentioned in the advance rate.
advances should be given notice. So that may not be a close relative. He may be distant relative.
Correct.
We don't know what, what.
Then can also put it this way. The executor shall inform
Ah,
the person named in the
That's
person's
correct.
name in the close directive
refer to
and
it
also
as-
his close relatives.
That's what we have said.
Yes. So he has to mention both to the person mentioned therein and also to his.
And what is the definition of close relatives in relative in section 56 of the Income Tax Act?
Yes,
That,
the Income Tax Act says lineal
No, that's
ascendants, lineal ascendants and descendants.
that's right. We have to
Companies-
go to the whole thing then.
Yes. But
So we are reading it out to you so that to make it.
No, and Companies Act define
The
relative.
listen, the executor shall cause to inform the guardians or close relatives referred to in paragraph 198.2.5 and his other immediate family members.
Yeah.
Of the executor,
That takes it.
etc.
That takes it.
That will do.
Yeah,
Then anything
one
else?
second below. Instead of close relative, near relative may be mentioned because near relative has been defined in the Transplantation of Human Organs Act 1994.
That's a good idea.
So we may mention near relative because this is statutorily defined.
But
in
this
the
is
law.
what this court has already pondered and thought. Let us not, create a complication.
No, I would request, please follow this because near relative is defined in the
They're
act.
telling you this is what the 5 judges have thought it fit to. Let us not tinker with it only to the extent that it is necessary we are doing it. Yes. Then 198.3.6, what is it?
Yes, I want your lordship to, I'm requesting your lordship to add at the end of if any, these electronic health records will be those that are maintained under the
198.3.
3.6.
A copy shall be handed over to the competent so-and-so, or the so-and-so. You want to add this also?
No. I want to add, instead of putting panchayat, etc., I'm saying if any, I'm suggesting there is a notification dated 30th December 2016, number 1100 of 2015, notification of National Electronic Health Record Standards. So now lordship will kindly just make a statement. Can you put it like this? The electronic health records will be those maintained.
So this is in addition to.
Yes,
The suggestion
yes,
is
yes, because the
not to
digital
do away
records.
with it. Not to do away with what is
No,
already
no.
there. That you don't do. You only want to add, executor may also choose to incorporate.
Yes,
May choose to.
yes.
The advance directive in their existing electronic health records, if any.
If any.
That, what do you say? That can be,
If something is available, it's,
that's right. Let that be added. We are not taking out anything.
let us not make it mandatory or this one is left.
It is left to him.
Yes.
So this will be added to this. What is already there, we are not deleting.
No, my lord. The point is,
Copy shall be handed over to the competent officer. That is a safeguard which has been put by this court.
who's the competent? Okay, leave it.
No.
Competent officer, the local government means secretary. Who is the person, if you want us to make it clear?
No. Now the point is, the aforesaid authority shall nominate a competent official in that regard who shall be the custodian of the said document. Now, once I'm putting my document in the electronic health records, and that is a statutory notification, why should I again go to?
The record, who shall be the custodian of that record?
Yes, but I'm saying the government of India is now having, we are a digital age. The government of India is providing for a national
You're
digital.
saying this is one by way of, hard, I mean, not, it's a real document you're having it. The other thing, you may do it if you wish to.
All right.
So if the hospitals may want to.
No, actually, the ulta is the situation. Handing over to the corporation is a big problem.
What is the problem?
There is nobody who nominated.
We'll make it
Not after Vishaka came for 11 years, nobody drafted the laws.
the secretary to the concern, because local department is panchayat, etc., etc. The secretary is usually the
National
executive authority.
Become impractical, but nobody hands it over to the government. Why do you
There is
enforce the
nobody, what
government?
they say, there is nobody who's competent body.
No, it can be this or that. Additionally, you can put this National Digital Health Mission thing.
Let him do it.
Ah,
That's what he
but it could be either. It could be either.
Yes. Or the person may nominate, give a copy if he wants.
Could be either, because otherwise, that National Health Mission thing is ultimately going to work.
That is electronic,
Yes.
electronic health record.
Yes.
And even they only want to, may choose to incorporate it.
No, it's already
What this
notified.
court has found that it should go into the
No,
panchayat.
that's why,
It is-
all right, both.
Both, that's what I'm saying.
Both,
Let
both.
both remain. And if you want, we can say the secretary, instead of the competent body.
Then can Lordship put it, instead of copy shall be handed over, copy may be handed over.
Then what is the record?
Why you want a record? Why do you want the record?
Then we'll be completely changing the scheme of the,
Then you can just put copy may be handed over.
No. Shall
Or let it be there. Let copy be there. It's not working. I'm telling you, Lordship, there is
just handed over.
handed over whom?
Yeah.
Handed over to whom?
Secretary, we are going to say secretary, we'll make it clear. It shall be the secretary. Because he is the person who should normally accept it. Can we say secretary?
Going to be
The local
unworkable.
board.
Or else would it be the alternative? Only my thing. Can be some local registrars, there are all the records will be maintained in the registrar office. If it is to be done, I think something can be.
Please don't send them to the registrar's office.
Very lively.
You know what happened.
I know that.
Don't send
I
any one of these people there.
So all the records are normally maintained in.
Even panchayat may not be much different.
But Mr.
You don't-
Natarajan,
Yes.
if this notification is issued,
Yes.
National Health, Digital Health
Yes.
thing,
Yes.
it is better you keep it, if it is connected and integrated with all the hospitals.
Coming, we are.
That will be definitely, that will take some time. The process is.
It's already there, notified.
No, actually what happens is, the red is only 10% of the whole.
I am,
192 is not.
Natarajan is saying it's all
and fluid
notified.
paras are not touched.
We'll check it out.
Lordship sees me not
You know, what
provide the.
Please see, brother. A copy shall be handed over to the, this is something which has been thought of by the default, by this bench.
Including,
We can add that.
including so and
This should be retained as
Mr. Datta, I'll tell you one thing. Whatever the exercise we undertake with your assistance in all, nothing can be made absolute. Nothing can be made absolute. So our only request is whatever the difficulty the people have faced in the given point of
Correct.
time, to that extent, we may take a call and clarify. Rest of the thing which has still not been operational, people have not come across those hurdles. Better not to tinker with the moment. We can't visualize how the things on the ground will work. So we want to make it, your anxiety and our anxiety is that it may work on the ground. So whatever the difficulty the people have faced to meet out that situation, whatever the alterations may be.
Yes. Instead of going on imaginary things at
Yes,
present,
that's
as
right.
in the situation emerges, we can take a call. These are all the.
This court can
It
always.
might happen, it might be the problem.
Simply make a law tomorrow. All these problems will be
The
over.
judgment also it said that the directive and guidelines shall remain in force till Parliament brings a legislation.
Important legislation.
So come up with that.
So we are saying this it will remain, so should we say the secretary? Brother, should we say the secretary?
Or can I suggest one thing?
What do you want?
Copy shall be handed over to a competent officer of the local government or corporation or panchayat as may be nominated, whoever is nominated, because now the point is this.
That is already there.
No, local government or municipal corporation or panchayat as the case may be.
No, next sentence you please
The
read.
aforesaid authority shall nominate a competent official in that regard who shall be the custodian.
So it is very clear, this court has thought of it, not as if this court didn't take of it. So we will only add this other thing, that red will come along with it. Correct?
Okay.
Then next is para 198.3.5 is to be deleted, you're saying.
Point seven.
JFMC's role is
Yes, yes,
family physician.
yes,
And that I don't think that can be deleted. Eh?
yes.
Okay, deleted. That is deleted.
198.4.1.
Then 198.4.
Now we come to the implementation stage.
That's right.
198.4 is the implementation. Yes. And there we get, my lord, this is where, my lord, we have, this is in consensus with the health secretary and the AIMS, my lord, 198.4.
That's right.
Yes. In the event the executor becomes terminally ill or undergoing prolonged medical treatment with no hope of recovery and cure, my lord, this I've added on the basis of Justice Chandrachud's judgment, para 475. He has added 3 factors. If your lordship wants to see that para 475, if your lordship wants to see it, so that it's not my addition. And this is also mentioned in the ICMR record, permanent vegetative like Aruna Shanbag. Persistent vegetative state. And when you say the treating physician shall assess, this is the primary board.
So you're adding vegetative state.
Yes.
Okay.
Lord, what Justice Chandrachud used, persistently unconscious condition is added at page 475 of the judgment, page 251. Page 251, para 475, 474 and 475.
So you can just add this. Or is it a persistent vegetative?
Then brother is saying in that the is in a is in a persistent vegetative state, we can perhaps consider that. The other portion we can't be adding. We can't be adding it. If we completely, it requires a lot of thought. We can't be adding it. Or in the state of initiation, you will give so much of discretionary power to the doctor can be capable of being misused, and we don't want that. So now the question is whether we should add or in a persistent vegetative condition. What is your view, Nataraj?
Before Lordship
Absolutely, I think that can be.
Huh?
He'll not be able to take any decision, and it is.
It is covered actually in the earlier.
In earlier one, it's covered actually.
Para 475.
Only it is only the explanation.
No, but what do you mean by persistent vegetative condition? Supposing there is a possibility of his being brought back.
Lord, it is defined by the Supreme Court. Persistently unconscious condition. Is an
Vegetative condition.
No, same parameter.
Ah.
Is an irreversible condition.
Irreversible.
Just 1 minute. With no hope of recovery and cure, that
Yeah.
is fact.
So what will happen if he is in a persistent vegetative condition? The life
Yes.
support system has to be withdrawn.
Yes, because is an irreversible condition in which thought and awareness of self and environment are absent. This is the concurring judgment of the Supreme Court.
From where are you getting it?
Para 475 of the Supreme Court judgment, concurring view of Justice Chandrachud, in the same judgment.
Then you'll be adding to the view of the majority judgment.
No, I'm just trying to, because
That will be basically,
no, but what I'm saying is,
so many.
That are our requests.
That is not.
no, but the otherwise judgment is confined to terminally ill alone.
That's it.
What about permanent vegetative state?
I don't know, it should have been done. It becomes a complete revival.
No, it's not revival.
We'll not expand that.
Mr.
We'll
Dadar,
confine only to.
Our request is only one. To the extent the difficulty have been faced in getting a particular directions of this court implemented in individual cases on ground, to that extent, because what has been expressed in 98 and all, it is a collective decision of all the 5 majority. And all have agreed to it. There may be suggestions given by other concurring views, but the final suggestions acceptable to all the constitutional bench is this.
That's right.
And from here.
Another thing, these conclusions are based on the discussions.
Yes.
Now here, if we are changing the discussion, this decision part only,
Yes.
without any discussion,
Yes.
Leave it.
then we'll go against.
Leave it. We have spent so much of time on deliberations, but if your lordship feels not possible for a permanent, not a person like Sona Shanbag, who is not terminally ill. He's in a coma for 9 months, 1 year, 2 years, 3 years. I leave it to not, I don't, if it's not going to be, we're only trying to make it as helpful to the patient.
Legislation comes. They also, day in and day out, legislation also come. And the legislator in their wisdom also think that it will work, but will never work on ground. And that's why amendments are made and we also sometimes intervene and shut down. This will always continue and there can't be an absolute system at all.
No.
Whatever the system can be made workable and we are able to get the acceptable results to the extent possible that we achieve the target.
I'm only saying we should not lose sight of the forest for the trees. What I'm submitting is, the idea is a person, he makes an advance directive, he is in a position he can't take a conscious decision. His chance of recovery is completely gone. There is no chance of him coming back. That's why the Supreme Court has said permanent unconscious condition. The ICMR uses the word permanent vegetative condition. He's like a vegetable. He's brain dead. Now there's a definition of brain dead. As Dr. Kishore mentioned earlier, the definition of death was the heart doesn't function, lung doesn't function. Today, the person's heart, lung may function, but his brain dead. The stem is gone. He has no chance of his recovering at all. He can breathe, he can pass motion, he can do everything. I'm only requesting now, since the Lordship is modifying, is the Lordship changing the judgment? I don't think so.
Make it workable.
Yes, let's come to 198.4.2.
In the chart, Malak, or in the judgment?
That's right.
In the chart, Malak? Yes.
I mean, 198.4.1 to begin with.
Yes.
When and by whom can it be given effect to? Just read that.
In the event, like the Lordship asked me the original judgment, no?
That's the original judgment. We have to read that.
In the event, the executor becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and cure of the ailment, the treating physician, when made aware of the advance directive, shall ascertain the genuineness and authenticity thereof from the jurisdiction JFMC before acting upon the same. So now
there are two key elements. One is he becomes terminally ill and with no hope of recovery and cure of the ailment.
That's a terminally ill ailment.
This is how you begin, trigger the sort of process. And then 198.4.2.
The instructions of the document was given, you wait by the doctors. It should be given effect only after being fully satisfied and the executor is terminally ill and is undergoing prolonged treatment or is surviving on life support and the illness of the executor is incurable or there is no hope of him being cured.
So will it not perhaps cover all this, what you're talking about?
No, the difficulty with doctors face was terminal illness is just one part of where there is no hope of cure. It could be a person who is not terminally ill. He's not ill.
Why were you not able to persuade the court to hold?
But the matter was reserved for a long time. I don't know. We argued all these points. The written submissions are there.
Oh.
We gave the ICMR. We gave all the directions.
Can't help it. They should immediately file a review.
So we may still choose to file a review. That's a different. Take instruction on that. We file a proper review. This one. Only limitation is the problem. Not condone the delay.
Limitation. Nobody who will look into limitation. That's a matter.
What do you say?
I don't think we should touch these issues in the
Vegetation
present,
issues?
yes, not in this
Vegetation
proceedings at this stage.
That was argued.
Not on this application or anything. Virtually, we are, I mean,
We are
getting,
not on that issue of whether review or miscellaneous application or clarification. Ultimately, we are sitting in this combination to see what, to make it workable,
workable.
not on the technicalities.
That's right.
The jurisdiction is not, you
That's
are
right,
not a
that's right.
jurisdiction, you are in a clarification jurisdiction. That will not come here.
But as and when the practical difficulty comes, we
That
can
will be
think of
right.
that.
That should be right.
On
But
imaginary grounds or imaginary situation, we did not do everything. Even after doing so many exercises, there will be again further, there will be some more
No,
clarification.
just see,
might be
please
required.
see
page 251 of the judgment, page 251 of the report. Just see that for a minute. Page 251.
Yeah.
Because lordships have held that the law under Article 141 is the law also mentioned by the concurring judges. Now, please see para 474 in page 251. Lordship has got that
251.
of the reported judgment in the SEC.
I'm also informed that the vegetative is a subjective term, it's not a medical term, I am told, by the doctor. So it will lead to a lot of,
No, my lord, it's part of the
A
ICM.
lot of,
Yes.
possible.
Possible
We don't know.
No, please see para 4. I leave it to Lord. If you want to drop it, I don't mind. These are,
How do you actually define a vegetative condition?
please see para 474 and para 475. Please see that. Kindly see page 251.
No, can I define PVS?
PVS, it's a medical
Yeah,
term.
permanent vegetative state is different from brain death, is different from coma. Permanent vegetative state means when the cognitive functions are intact, except the responses. The person is listening. There are eye movement. Person sometimes smiles also. Person sometimes weeps. The person is passing urine. Person is passing stool. Person is perspiring. Person is digesting.
Yeah.
Person's beard is growing. So the person is very much alive. The only thing is that his cognitive function is lost to a particular extent of perceptivity. Not in to respond to those perceptions.
So will such a person be able to signify, if not through words audibly, through signs? I mean, please take it off.
No, he cannot. Sometimes
He is not in a coma.
And he can't respond at all.
he cannot express himself. While in the brain dead, the person is dead. He is not perceiving us.
We follow. Now, in the case of a person who goes into persist and a permanent vegetable condition.
PVS.
That's right. Are there cases where they come back?
Yes, they may come back even after 20 years. Because then I have filed a list of 20 cases when I argued the matter before the Honorable Justice Deepak Mishra Sahib.
Oh, there is a possibility. Why we have asked you that question?
It's a very much viable possibility.
Oh,
Persons have returned even after 20 previous automatically.
therefore, we will.
We cannot say that the person is condemned to die.
That's right. So what are we talking about? We are talking about somebody in his pink of health, or perhaps lesser state of health. He making a call. We taking a call. If I am terminally ill and there is no chance of my recovering, these are the things. Please don't trouble me. I am prepared to go. As contrasted with that, this is a case where it's not a case there is no chance of recovery, as the doctor says. It's possible that he may come. Now, who does not want to live a little longer if it is possible? But for the terminal cancer patient, everybody wants to see a little bit more. Where will you go? We don't know. So,
Well, as it is said, everybody wants to go to heaven, but nobody wants to die.
exactly. So this is a very contentious area. I personally would not want to.
Drop it, Malad, drop it. I mean,
That is why yesterday also I had submitted that.
What is your stand? What is the doctor's stand about this vegetable condition being added as a condition?
No, clear no, very clear no.
It should not be.
It should not be.
drop it, Malad.
PBS
Look at
has a very uncertain outcome.
Malad, the Indian Council on Medical Research has said it should be a condition.
That does not go there.
Yes.
Because if I
Malad, let's not waste it. Take a lot of time. Malad, just put terminally, let's leave it, Malad. I don't want that.
That's already there. So let us drop that.
No,
that is instruction for me also.
Malad,
That is instruction for me also.
So it is very contentious. We don't do that.
I took it because the concurring judgment says there are three conditions.
I mean, let us not go.
Leave it.
So that's the end of it.
Yes.
So 198.4, the only difference we will have is that JFCM part will have to go. My learned brother was pointing it out.
Yes. No, and Lordship will say in 198.4.1.
You did not notice it. 198.4.1, please read. When made aware of the
I deleted the bar.
the genuineness from the JFC,
No,
that will go.
Next page.
Next page, bottom.
Where,
Page struck out.
Next page,
next page.
Below
there
page 5.
itself. In the black, after red, black. No, next page. There itself. After red, black.
Lordship
Next page is this one.
Page 4. Please see page 5.
Oh, you have deleted it.
Yeah.
Okay.
May I request your lordship to cut off that vegetative state there, in that reading?
Yeah, we are cutting it.
Yeah,
off.
cut.
We are not going to take it.
The entire reading, you're cutting it off. Persistent vegetative initiation, all that your lordship is cutting it out.
So then 198.4 will entirely will go.
No. Only the first part. The treating physician shall ascertain whether the patient possessing, that's part of the health ministry's also guideline that they must have a primary board, secondary board, all that is there.
So shall 198.4.1.
But earlier what happened, the JFMC,
Shall ascertain the genuineness.
but earlier what happened was the decision to pull the plug was with the judicial magistrate. So JFMC will take a decision on the authenticity and genuineness. Now we are saying the JFMC has no capacity or no time to decide with the genuineness. It has to go to the primary board, medical board. That's also the view of the health ministry.
No, that now the treating doctor will actually find out about the genuineness from whom. If you believe the JFCM, from whom will he ascertain?
The primary board, no, that's coming next. There's a primary board of treating physicians and one independent doctor, the 3-member committee.
What?
Not yesterday, we gave a chart.
The primary board has got nothing to do with authenticity of the
Document.
advanced directive.
That will be done by the primary team now. They will know there's an advanced directive. It will be part of the digital records.
What you are saying is, kindly read 198.4.1. In the event of the executor becomes terminally ill and is undergoing prolonged treatment with no hope of recovery, cure the ailment, the treating physician, when made aware about the directive, shall ascertain the genuineness and authenticity thereof from. This is a sentence which you will have to delete. Shall. So then he will, the treating doctor will find out about this. He is made aware of it. Let us see how it imagine it. It's being brought to his notice. This is there.
That's all.
So what this court intended was that it should be made aware. The authenticity should be established from the JFCM that we are deleting. So he should be made aware from about the authenticity of from whom. Because we are actually given that task to the notary or the gazetted officer.
That's only for maintaining records.
No, they are the persons who will be doing that verification. You see, 198 point, kindly come to 198.3.1. We have replaced the judicial magistrate with the notary. So when the treating doctor, he will have to ascertain it from the concerned notary public or the gazetted officer.
Or the close relative also.
Right?
Or the close relative also. What you will imagine, not a person is in the hospital.
That's right.
Now the doctor has to decide, is he going to go to the notary public?
That particular relative is very keen to knock off the
Yes, possible. I'm not saying no.
So then how?
So that's why the National Digital Health Record is there.
What if he doesn't make use of that? If not everyone who is
Because then there's no directive.
So therefore, what you're saying is, why not replace? We have replaced the JFCM.
Yes.
With the other man, that is a notary at your instance.
Yes.
So he can ascertain from the notary public.
Only there's a doubt about the genuineness.
That's it. I mean, that
Yes.
is what.
Correct.
Otherwise, we will be knocking off this.
That's what I'm saying. So the point is, because if there is a doubt about the genuineness,
ascertain the genuineness and authenticity from JFCM will be knocked out. From
the lordship is when it says that the health team has to go to this gazette office, the notary public, and find out the document is genuine or not.
Going by the decision.
Possible.
This should be done before
You
actually.
might as well close it, brother. It's not going to work out.
No.
This has to be there, Datta. This is a part of the.
How can the doctors go to the notary public and decide? It's not possible.
No,
Not like the Apollo Hospital situation.
I was just going to say, suppose you are keeping it in the digital format
Yes.
with the National Digital Health Mission,
Yes.
this thing portal, whatever it is. So it would be much easier for the doctor or the treating
Once
team or
it
the
is
relative.
part of that, it is presumed to be valid.
If there is a digital format documentation
It's already there.
with the National Electronic Health,
If that is done.
National Digital Health Mission.
then that is an authentic thing. I
If
mean,
that is done, he need not.
that's right.
But if it is not done by.
So that option should be given here. Instead of, JFMC,
We'll have to rewrite the whole thing.
no, that could be an additional thing, either here or there.
I'm not
all over the world, all they see is a directive signed by two witnesses. We have to, doctors are saying,
Made
"Please
aware
trust
of
us.
one
It's not that a person is going to be start peeling off.
genuineness and authenticity from the, what we will do is from the testimony. Getting appropriate.
But let's see, it's 198.4.2 also before.
So what we can do is,
Yes.
because in 198.3.6, we have said the executive may also choose to incorporate advance directly in the existing electronic health records. That is done by him. That's a digital thing. He can ascertain the genuineness with reference to any existing to
Can I put it like this, Murad?
advance.
Murad, can I put it this way, Murad?
Entered in the existing electronic health records.
What is the precise thing, just so that it gets?
I just don't interrupt. I'm suggesting.
In the absence of the same, the genuineness shall be ascertained from the notary public or the, what do you call it? What is that officer? Gazetted officer. Refers to paragraph. 198.3.1, 198.3.1. That is what we are proposing. We'll read it out.
Yes, yes.
198.4.1 will read, in the event the executor becomes terminally and is undergoing prolonged medical treatment with no hope of recovery and cure the ailment, the treating physician.
Actually, the treating team of doctors, so putting physician, they should not tomorrow say physician is different, surgeon is different.
Isn't that? Treating physician, there will be one physician at least. Yes. When we are talking about MD and all that, it's not that, it's a treating physician.
Okay.
When made aware of the directive, advance directive, shall ascertain the genuineness and authenticity with reference to any
Electronic health record.
any entry in the electronic, in the existing electronic health record, if any.
Or with the custodian as mentioned in 198.3.
That's right. That is.
Or with the custodian
Or with the custodian, that
as
we can
mentioned in
take.
198.
Or with the custodian. So that's the simple thing. Then what else is there?
Now this is the main thing where all of us are agreed upon.
Oh, the main thing is coming out.
No, this primary board, secondary board.
Okay.
Yes. Because in most jurisdictions, there is no board. Because even the concurring judgment says that once I've given my advance directive, it's called subjective second standard. That is, I've already given the directive, so don't now second guess me and reconsider it. But we are putting safeguards that just because the directive don't do, let it be subject to us. In fact, I'm told that primary board is contrary to a principle of advance directive. Please come to 190.
And 198.4.2.
Yes. If a valid advance directive exists, the hospital where the patient is admitted shall constitute a primary board consisting of 3 doctors on the patient's treating team. The primary board shall satisfy itself that the executor is terminally ill and is undergoing prolonged treatment and is surviving life support, or illness is incurable and there is no hope of excellence. You can cut off permanent vegetative state. Please cut it off. This is from the ministry, this particular paragraph.
That's all. Only, please cut off only permanent legislative statement or is in a
And
permanent.
the other thing also, initiation, escalation, all that, that will all go.
That's also not necessary because if there's no hope of being cured, that's
That will
enough.
take care of everything.
Yes, your lordship is right. The whole
So
thing,
bad, therefore, now what is the existing 198.4.2?
there is no board brought. So the ministry suggested that there should be a primary board.
198.4.2, 98.5. Instructions in the document of the given due effect by doctors. However, it should be given effect only after being fully satisfied with the terminal and so on. What is
Who will be satisfied?
Huh?
Who will be satisfied? So primary board.
Yes.
It was silent as to who will be satisfied.
Without directing. This is matching.
What says is only the doctors, which doctor, there is nothing, it's very ambiguous. Therefore, it is said that let it be by the board, properly duly constituted.
See, that is made clear in the next one,
Yeah.
198.4.3. Because this is kind of a general thing. What is to be done by the treating doctor is, if the physician treating the patient is satisfied that the instruction given in the document needs to be acted upon, he shall inform the executor or guardian, close relative as the case may be, about the nature of the illness. No difficulty. The availability of medical care, consequence of alternate forms of treatment. He must also ensure that he believes on basis of whether the person understands whether it's a coincidence or concerns. So this is what the treating doctor should do first.
For which state?
Correct? Then the physician, next is 198.4.4, it is very carefully thought out. The physician hospital where the executor has been accredited for medical treatment shall then constitute a medical board consisting of the head of the teaching department and at least 3 experts from etc. Who in turn will visit the patient.
That's the 198.
So what is wrong with
No, 198.4.4 is unworkable.
Why?
It's unworkable because head of department, at least 3 experts from general medicine, cardiology, neurology, nephrology. We simply saying, not this, the Ministry of Health also agree that this is completely unworkable. Just have a primary board.
What do you mean by primary board?
Primary board is the first board which takes a decision.
What is the composition of the
Composition, the treating physicians plus an independent person. That's what the ministry says, bro. I have no problem. And as the Lordship pointed out, where is hepatology, where is pulmonology?
I withdraw it.
Review.
My lack of knowledge, that's all I can say.
No, I'm not, these 198.4.4 is.
Why do you say it is unworkable?
That's what doctors tell me, my lord. Now, please read it, my lord. The physician hospital where the executive has been admitted shall then constitute a medical board consisting of the head of the treating department and at least 3 experts from the field of nephrology, etc., etc. Then there's a further direction that it should be 30 years experience. All those things are there. We are simply saying make a primary board.
These are all value judgments which have been.
And one more thing in our application,
We'll change the judge, what my brother says, we'll be changing the structure of the judgment, entire thing. It was carefully, when you said it was reserved, a lot of thought would have gone into it,
I'm just pointing out, it's not
Right.
going to be workable. It's not going to be workable.
Practical difficulty.
So the whole exercise
You
of
want to
the,
make it more easy, more
But-
smooth.
well, I'm
But,
saying when
No, one thing
doctors and the health ministry
is 198.4.4. Such a board, just envisage in any hospital, such a board, just the nomenclature of the board that is given. Try to think of existence of such a board in a, not Kerala, but in a other Mufassil hospital or something. Such a board cannot exist.
No, you will have a hospital where you're going to see, first of all, we are.
No, we are looking at the
We are
patient.
talking about, now ordinarily, nobody will do this, first of all, to begin with.
No, that's
So we have to begin with a certain socioeconomic strata of people who would want to do this. Let us take it that they would go to what the court contemplated. That they would have this facility. If you want what we can have, they can always call for experts from other hospitals. It is not necessary that the expert from may be working in the same hospital. You see, what you're saying, if we are
Lord, I want, my friend points out that these guidelines are not only for advanced directives, but also where no advanced directive is made. And I've given in my paragraph, in affidavit, I've given 7 paragraphs why this is not workable.
Well, then constitute a medical board.
Yes.
And so consisting of the head of the, let us go. step by
no,
step.
no, that's-
Let us just, head of the treating department will be there. Every hospital, if you're going to have some major, if you're going for oncology,
I mean, before,
no, we just, I'll give you an
no,
example.
because at least on this point, ministry also wants change, my lord.
We are not going to think that the ministry is always.
No, I'm saying this is thought of by the
Okay,
games.
kindly
Sorry,
bear with
I'm
it.
apologize.
Bear with it.
Okay.
Let us read together. Shall constitute a medical board consisting of the head of the treating department. Okay. Now we are talking about a terminal illness. No hope of cure. I mean, no possibility of cure. Now let us take oncology. You are contemplating a situation where the oncologist, there will be a head of the department. There will be somebody who in every hospital who will be designated as the head of the department. That person will be there. So then comes.
In many hospitals, it may not be department, it'll be just hospital, 3-4 surgeons.
Go to a
45-bed hospital, 30-bed hospital.
You should go to a hospital if you want to get all this. You should go to a hospital.
No. I mean, if we go to a hospital, I may go to a nursing home which may not have heads of department.
Then what should you? How would you verify all this? If you are going to say, I want to get if you want to say that I want to get the benefit of the judgment, and I go to a nursing home where you just have an MD.
No. I'm saying you may not have departments of oncology, neurology, cardiology. That's what I'm saying.
Get a doctor from outside. We can make that clear.
No, but
Is that
no,
we are
which-
telling you
which
find
doctor
something
gave it?
inconvenient. You're taking away somebody's life support virtually. You're going to say that please make it even more convenient so that I can go.
Take
I'm
away
not
the
saying
life of
that.
some other,
I'm saying that.
so that I can take away the life of some other person.
Some other person.
So I'm only saying
What
primary
is
board and
that?
review board.
Is he correct in saying?
So I'll show that
What is your suggestion about it?
Actually, the department wanted to have board in a particular place. Board should be there instead of giving a very vague expression that it should be by the doctors. See, they wanted it because we are,
That's right. The the health condition
Yes.
requires a multidisciplinary
yes. In
examination.
different conditions, different situations, we can't visualize at this stage. Therefore, they wanted a board, that's all.
That's why the court also thought of a medical.
Yes.
So that they should go to a hospital where these facilities are available.
Yes.
You cannot simply go to one clinic and say that this.
We can't, yes, we can't do it.
To get the benefit, you will have to go to such a hospital.
It's a hospital.
consisting.
But
Because the thing is that you are actually taking in the life of one person.
correct. You are taking away somebody's life.
So like-
No light.
continue tomorrow.
No, you continue today.
Okay, please.
My brothers agree for some more time we can spend so that we can dictate. If you all agree. And close it.
If you see the entire list,
Tomorrow anyway, we don't have any. No, no. It's not saying that.
Right now it is 4:30.
Take one. That will be over. That's all we want to know.
the suggestions are ready. Definitely it is going to take another hour. That's what I feel. Because it's a-
You want to go somewhere?
No, I have no problem. I can sit even 6 or 7. There's no problem. But
Suggestion in this particular.
No, that is, doctor, you have given very invaluable suggestions, including particularly the vegetable condition. Your suggestion was very crucial. So let us first be done with him and thereafter we will consider.
What were you saying? What is the list?
About this medical board, do you have anything to say?
Yes. I'm talking only precisely on this particular point. So the medical board should be of 3 doctors.
Yeah.
Number 1, the treating physician.
correct.
Number 2, the superintendent or the director of that particular hospital. And number 3, a specialist from the specialty concerned. Suppose there is a patient suffering from carcinoma, we can call an oncologist. If he is suffering from renal failure, we can call a nephrologist. If he is suffering from neurodegenerative disorder, we can call a neurologist. If he is in deep jaundice, we can call a
I'll
hepatologist.
give you a practical example. I'll give you a practical.
Even the practical example, only 3%.
No, doctor, I'll tell you, give a practical example. I know there's a hospital in Kerala where I used to go. That the medical director, he was a MD in medicine, but he went and studied in CMC Vellore, passed out from Vellore. Supposed to. He was designated by the hospital as a medical director. He was not a super specialist at all. In most hospitals, you find, even present man I know, he's an MD in general medicine. Maybe maximum exam DM. Correct? Now, if the treating physician is also an MD in general medicine, so you will end up having, out of the three, you will have 2 persons with MD in general medicine. So the whole point of having a multidisciplinary board, which was in the mind of the court, that will be lost. You see, when you talk about a genuine multidisciplinary board, the whole idea is you're taking a very vital decision affecting somebody. So they wanted this court intended that all these disciplines are those disciplines where you could have the possibility of a terminal illness becoming so bad that you need to have all these relief. So that is why, I don't know whether you should tinker with it. You can add something more or something.
I think doctor's suggestion of having a team of 3 doctors makes more sense because it simply says the treating doctor.
Not the medical director. Not the medical director. You may have nothing to do with
Depending upon the terminal ill. What is the terminal ill that we will have to?
No, because we want
What kind
an
of-
odd number. An odd number. One is the treating doctor. I'll put it this way. Typically, if a person is having cancer, now if he is in a reasonably good hospital, he'll be treated by an oncologist. So already the treating physician is an existing
So he'll
oncologist.
be the head of the department.
Yes, so what the ministry also
He'll
suggests,
be the head of the department.
may not be, he may be a junior doctor also. We don't know, in a large hospital. So he may be a junior, I may have, the large hospital may have 5 oncologists. Everybody may not treat me. The senior most person may not be treating. So,
So if a junior doctor,
no, we are just talking about safety mechanism of safety.
if a junior doctor is treating him, it will be very, very unsafe.
No, I'm saying he will be 20, he may be 45 years old. He may not be 60 years old. He may not be the head of the department.
That's right. But
Yes.
if you have somebody with greater experience,
Yes.
he will take an independent look at it. See, the treating doctor may have a particular view.
But this 194.4 is not going to work because you can't have because time is of the essence. The person is terminally ill. He's brain dead. You take
Name
a
the major hospitals in Chennai, you're familiar with, Bombay, and you say that this will not work.
But we're not doing for, not meant for the big hospitals.
No, I just want to say, I come from the northeast part of India. I can visualize only the Guwahati Medical College and 2 other medical college having this kind of a
Throughout
situation.
Northeast. Correct. Throughout Northeast.
Throughout northeast, other 6 states will not have,
Uttarakhand also is like that.
not a single hospital
Uttarakhand
in the government sector also. So therefore, this is not
Sorry, but many people are coming. Lordship perception, it's only by a small class. Many people would want to do this once they know it. And the Lordship sees in many towns also, there are chartered accountants. Even in a small town, there is a chartered accountant, there are advocates, there are professionals, architects,
who want to be.
who can take advantage of the advanced directives.
So they should go to that appropriate hospital.
Not to a clinic and then
No, no, I'm-
take away the life of a person by sin. So you will have to visit to a particular hospital where some such facility and doctors.
Just imagine a junior government servant, his father has a cerebral stroke, he's terminally ill. Now, are we going to tell him that, no, if you want to have this advanced directive, you must go to Apollo Hospital and
Not
go there.
Apollo, not Apollo.
Government hospital.
No, these facilities, we cannot say that these facilities are available only in Apollo.
No, but I may say, let's say, for example, suppose I'm staying in, say, GK, Greater Kailash in Delhi. My father has a stroke. I take him to that local hospital where 25, 30 beds are there. There is a team of physicians. He has made an advanced directive. They don't have a team of oncologists, nephrologists, they don't have. They've got a team of doctors who are doing it. They get treated. Suppose it's only a cancer hospital. They have no other department.
Lata, when you say,
The point is, what is the purpose? What is the
That's right,
purpose
that's
of it?
that-
We are having a prime first.
Lata, you kindly come to 198.4.4 once again. Does it anywhere say that the members of the multidisciplinary team should be of that particular hospital?
It makes all the more difficult.
No.
Please see
You're saying it.
please see the
that
feedback of the doctors.
Ordinarily, you would, when you go to a particular, when you're talking about terminal illness, and you're diagnosed, you're getting this treatment, It will be in a hospital where these facilities will presume it is not. We assume it is not there. We are
Suppose I'm in a northeast state, sir.
So we are correct. We'll assume it is not there. Just see what it says. A medical board consisting of the head of the treating department. I think that there's no difficulty with that. And at least 3 experts from the fields of so-and-so, 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 with overall standing, who in turn shall visit the patient in the presence.
Correct.
Now, they would not be drawn from that hospital. We are trying to tell you. If you want, we can clarify that.
I've got 3 affidavit. Doctors have said this is not possible because suppose I'm a.
They don't want to call doctors from outside.
But they have to leave their work and come here. The 4 people must come. They must come at a particular point of time. But I'm just saying, let us see from the perspective of doctors, not from what we hear.
One thing I suggest, Datta, you think if we reduce the number of members of the board,
Microphone.
make it workable, one thing. The treating doctor and 2 other experts to have a board to examine.
And that's the primary board.
Primary board. Leaving apart oncology, this. Expert means the director, the person who constitute the board, keeping in mind who are the experts in the relation to the sufferings of this patient. And accordingly, board will be constituted.
Right.
Not possible?
I'm telling you, Justice Joseph is asking you can call doctors from other hospital. I'm looking at a scenario where in the entire town or the city, in a given hospital, this is not available and forget about getting somebody from outside. Experts are simply not available. I'm talking about a scenario which I am familiar with. It may not be replicated all across India.
I am also suggesting to myself, if a person has got say 15, 20 years of practice, I mean any good doctor, anybody knows that this is a person who's terminally ill. Suppose the cancer report says he's got the 4th stage. It has metastasized. It has gone all over the thing. Then do we need 4 doctors from 4 teams to come and opine and all that?
We do not know.
That's why they say terminally ill. That's why they say terminally ill.
Well, the decision is also very critical.
No, the point is, how should the board be? That's the only question.
And why should we also distrust the doctors who will be opining as to the condition of the patient?
Please see the affidavit which you prepared. Manoj. I spoke to doctors from Bombay. I spoke to a panel of doctors from Madras. They had a meeting in my office. I went to Madras Medical Mission. I spoke to the doctors. We took all the trouble.
So what
They say, look, it is impossible. Even in Apollo Hospital, where do you get the time to call all the team? They will summon the team. Director will come. Everybody will come. They will meet. Then you get a further report. It's not possible. And how many people go to Apollo? How many people go to?
Task is a serious task also.
Can I suggest?
Whether make
Let
somebody
us read
leave or
once again.
Sorry.
Mr. Datta,
Sorry.
let us read.
Apology.
The physician stroke hospital where the executor has been admitted for medical treatment shall then constitute a medical board consisting of the head of the treating department and at least 2 experts from the field,
must have gone. Yeah.
then leave it with overall standing in the medical profession who in turn shall visit the patient. All these
20 years, etc. is gone.
So leave it and have a trust on the person who is constituting a board to make it workable and meet the requirements.
Then we need not have a review board. Then one board is enough.
If they want.
Otherwise, we'll just go on here and there.
No, actually, when I discussed with the doctor, suggesting, suppose there's a board like this. Should you have a review board? One viewers don't have a review board because the primary board has taken, that's enough. And the patient has said, allow me to go with peace and dignity. Only thing what the ministry's suggestion was that since you're taking away a person's life, let that thing be reconfirmed by one more, like a review.
Some second balance.
Second.
Why do you have at least executive instruction pending? Then it will have a status of law.
Take away somebody's life.
Instruction is that there should be 2 level, 2 tier.
Often that Justice Desai has to say that above me is only God.
Instruction is that there shall be 2 tier check.
So what do you say about this particular clause, 4.4, about the composition of the board?
composition, the instruction what I got is a board comprising of 3 subject experts. That's what they said.
3 subject experts.
Subject experts.
That's
That's
all that the court was also
yeah.
saying.
It's a
Subject expert means who? What subject?
subject depending upon
Where
the
the illness of
illness.
that patient.
Illness.
Relevant to the patient.
You're putting subjects and all, that is critical.
No, relevant to the patient.
Obviously,
Obviously.
you have to trust somewhere the person who will be called upon to constitute the board. He'll constitute the board in reference to the subject which the patient demands.
So they'll call the anesthesiist,
Yeah.
head of the department,
And
and they will call, if, it can fall into disuse. I mean, please, there's a public in the situation, mind you.
No, the doctors have repeatedly
What we are-
said, you
what
please
you're-
trust us.
What you're asking us to do, mind you, because it'll apply throughout the length and breadth of the country, there will be a lot of people who can be taken for a huge.
Lordship,
Please just be reminded, I'm telling you,
I'm not,
with all respect to you, we are telling you.
yes, but also the point is, this advanced directive is there in multiple countries.
We don't
No, I'm just telling you, Lordship.
don't compare.
No, I'm
I'm
just,
talking about the Western countries.
I'm talking about
Where in India it's capable of being misused. That is why they spend so much
I'm
time.
asking myself, how is a person in Bombay different from a person in London in terms of hospital care? People are coming here for treatment. So I'm saying misuse may be in the villages where the person is illiterate.
this,
And what the doctors are saying is,
Yes, let us hear.
and one more requirement which is suggested was that in the primary board, there shall be one gazetted officer
Ah.
who shall, actually, he should either record his satisfaction that it was being done by the board and he shall be part of that board.
Oh, my, that will be adding in.
It is required, that's what they say, because tomorrow that particular board, if it takes some decision or anything, there must be some kind of authenticity for that.
That is not bringing more bureaucracy. May not be, will come, what you want about this is, what you say about this 4.4.4, 198.4. You are saying, what are you saying? In place of this, and at least 3 experts.
Yes, 3 subject experts.
Okay.
Yes. 3 subject experts and 1 gazetted officer at least.
So,
That's
but
what
I think Justice Rastogi suggests very practical.
what we
The
can do-
doctor plus 2 more experts is enough.
2 more experts in the relevant.
Leave it, just say 2 more experts. Let the doctors apply that. Let's trust the
2 or
doctor.
3 subject experts.
Two.
Subject experts.
2 more
Treating physician
and 2 more experts.
and 2 more.
They have somebody in the
You have to
relevant
keep it in
field.
odd number. Board has to be constituted always in odd number.
Yes, so treating physician and 2 subject experts. Leave it at that. Let us see how it works out.
As far as possible.
Of at least 20 years, and that also you want to knock out. Not necessarily, 10 years sufficient.
But then why 20? Why not 30? Why not 10?
No, that's what the court has found.
That's what I'm saying. It's not practical. But the reason why we have taken so
You
much of
don't
trouble
find
is,
anyone with 20 years experience in anywhere in India.
but suppose the person is 18 years. The one doctor is 18. Suppose the man of 22 is gone on leave. But
So that are considering our jurisdiction.
yes.
We are not a reviewing court. To what extent we can tinker with the directives,
No, but the point is,
the substantive judgment,
no, the point is,
which is.
if it's a board, if it's a medical board, you can always modify the medical board in the light of experience.
So
There is
where is the
because-
study that?
Yes,
is
my
not
affidavit.
workable?
I got 8 pages of affidavit.
That's
So
my
you-
own.
Even the views, number of experts from 3.
He is also an expert. In law with 5 years also equally an expert.
Even one day is expertise.
No, but in fact, there's
At least
a cynic said,
At least they are learned friends.
That's right.
With 1 day experience also.
They are learning.
They are learned
no,
friends.
in fact, somebody said when you say 10 years experience, it is the same 1 year multiplied 10 times. He's not done anything beyond. So that's a part. I'm just saying 20 years was unworkable because sometimes why keep it 20 years? Keep 3
What
experts
is
and
the
leave
view
it.
of the court? 20 years. 20 years. 20 years, what is your view? It should be. What is your view about 20 years being knocked out?
I'll not be able to have it executed.
No.
If I remain in my part of the country, I'll not be able to have it executed.
You don't remain in the middle.
That I don't know.
So what did you guys?
It's unworkable actually. 20 years.
You see, we have to leave.
Now, why should we think that somebody with 20 years experience is in a position to know the condition of the patient and somebody with 10 years experience is not in a position to know? If there's a rationale for 20 years, one would
That's
stick to
because
it.
of, the proportion it bears to the importance of the, the decision you are taking.
Lordship may say 10 years, if an advocate can become a judge in 10 years, why not? Doctor in 10 years become an expert.
So there are practical difficulties in some of the remote village areas and all to get the
You will not
more
get 20
experienced
doctors.
doctors. That is the one thing they thought of and
But those who are super specialties,
You think there's somebody.
they
in the
become
village going
super
to do all
specialties.
this?
Tata, if I'm
nothing is going to happen in this one, that much
My
I can
experience
tell.
goes.
They are more concerned with
Super
having a
specialty doctors
physician
come
there.
at the age of 34, 30, 33, 34, 35.
All these courses.
Super specialties, yes. Because so many problems are there. So by the time he has 20 years experience, he is 56. Doctor, sir, correct?
Yeah, you are right. You lost me.
So by the time he has specialty with 20 years, his age class 56, 57.
That is why.
Your the diagnostic acumen, the professional equity is not related to the years that one has passed after obtaining a degree. Institute of the person.
The person.
That is what I tell you.
I have
Why do you specify the number of years?
You want to make
Okay.
it 1 year.
No, I want
Yes,
to
that
leave
is
the
valid.
person who's constituting the board.
That's,
Subject experts will do.
there's simply no,
Why? What is?
no mention about the year of You-
That's all. If you want to.
It's not a word.
You had introduced yourself as I am having so many years of experience as a doctor. That has its value.
Rajan, what do you suggest?
Amendment of conscience, if you decide, make it 15 years. it may be-
criteria, not.
We are only putting the problem on the medical field. If we are going to say it's a judgment, we will not change it, then it's a different.
Now, Rajan is the arbitrator.
Again and again, we are thinking.
No, Lord, please, look, this is not a judgment like a law which can't be, we are talking about human condition.
Again, we will have to think about one thing.
Yes.
5 learned judges, see, they must have spared so much time. And they fixed it
Yes.
and now,
You're diluting it.
Yes, but now what has
and
happened?
also we will have to take it up.
Now doctors have now said that please don't put 20 years. Please don't put judicial magistrate.
That we have
This why,
understood.
this why, therefore it is
15 years,
possible.
Okay, put 15 years, no, leave it, no, let's not waste because.
That's
Yeah,
You know, I have worded it in a very simple manner.
Ah,
All controversy will go.
ah,
I'll read it.
ah.
It's 2 lines. The final decision of withholding treatment should be vested in a committee comprising of the treating doctor, the superintendent or director of the hospital, and a medical specialist of the concerned specialty. Now, I would like to define what is specialty. Nowadays, we are talking of subspecialties.
Super specialty.
So, and I have not mentioned subspecialty. Oncology is a subspecialty. A surgeon is also removing a cancerous growth. And a general physician is also treating a patient of jaundice. Everybody need not go to a hepatologist. A person who will be MBBS, he is also treating urinary tract infection. Not that everybody should go to a urologist. So this concept of subspecialties is contrary to the general theme and philosophy of medicine. Because firstly, the subspecialty is simply a part of the medicine. I have been taught, even before I did my MD in radiology, I was taught about radiology. It is simply a matter of refinement of my knowledge. So a concerned specialty means if there is a growth in the breast, a surgeon may remove it. So that surgeon will see. Number one. Number two, all the board has to certify is that whether the illness is terminal or not. He is not under obligation to diagnose it. Terminal illness is a clinical condition. And that will be there very clearly visible to any specialist. So we have to certify that the patient is terminally ill. He does not have to go into the diagnostic aspect, fine tune the diagnosis. That is already there. So 3 doctors are sufficient. Now, why I included the administrator of the hospital? Because there is an executive dimension to it. So he will be knowing whether all documents are in order or not, whether all necessary legal formalities have been completed or not. So it has got an administrative angle also, while withdrawing or withholding the life support. And that will be the person in charge of that hospital will be the ideal person to take count on this.
So what we can, after hearing, what we can possibly do is, with our consensus, the physician hospital of the doctor where he is being treated shall then constitute a medical board consisting of the head of the treating department. We take it that you have no difficulty with that.
No. Treating physician.
Not head of the, just treating physician. Not head of the treating physician.
Not the head of the department. The physician who is actually taking care of that case.
Okay. The treating physician.
Then
the treating physician, just let us try it. We are trying to find out. Treating physician, head of the department goes, say the treating physician. And at least
the superintendent of the hospital or the director of the hospital.
And at least 3 experts.
Superintendent is director of the hospital.
No, don't bring the
The
superintendent.
head of the unit,
Don't bring the superintendent because he may be having nothing to do with the particular disease.
Documentations.
Documentation.
documentation, given formalities.
So his expertise may not be of that use. You can have him as an additional member, that's okay. But otherwise, what this court intended was, not the person who may be a medical director, for example, he may be the one who is actually running the hospital. He may be the businessman. He may be the he may be the director of the hospital because he is running the hospital.
Ultimately, if I may say so,
Don't do that.
what the Supreme Court wanted was, before somebody's life is taken, it's an informed, thought out decision.
He will inform the family members and everybody. He has to discharge administrative functions also.
There has to be many layers of decision making.
So there are several layers in the decision making. One is the clinical decision making. Another is the administrative decision making. So one administrator, because
It can be that medical director can constitute the board. The medical director can constitute the board. But he should not be a part because, we can point out hospitals where the person who is just barely the past year because he is running the hospital.
Or the son of the founder.
Son of the founder, I can give you, if you want. He's become the director, it will be catastrophic. Yes.
No, Lordship, his simple point is, the treating
So we are
physician and 2 other subject experts, as Justice Rastogi pointed out.
Not two other. There we'll be completely tinkering if you make it 2 other.
Yes.
Let it be 3.
belong to the
Or and make it cheap.
human organs and
And-
certified brain death.
And at least 3 experts from the relevant.
Lordship, at least 2.
Relevant fields of medicine.
Correct.
Instead of, confining it to this.
On it.
Milord, when in the transplantation of human organs, when we certify brain death,
Whether
this is the combination.
Lordship, just see, my reverend friend
they
is.
are having a
Or my
conference,
colleague.
you don't bring the conferences.
Sorry, sir.
Treating physician. The physician hospital shall constitute the medical board, cannot be. We will make it the medical director, the medical director of the hospital, wherein has been admitted for treatment, shall then constitute a medical board consisting of the treating physician and at least 3
Subject experts.
experts
From the concerned specialty.
Yes, from the concerned specialty.
that can, subject experts of the concerned specialty.
It is specialty. Specialty is a generic term.
So what about this, and at least general medicine, etc., that will go?
All go, not miss it.
Because there is an end to it, you see, it says with experience in critical care. That will go there.
Critical care, no need. Concerned
But you may not have
specialty.
ICCUs everywhere.
Treating physician. 3 experts, at least 3 experts from the concerned.
Concerned specialty.
But the only thing of 1 plus 3 becomes an even number. Odd is always better. But anyway, lots of
So we may put two experts are sufficient from the concerned. Why 3 experts?
Why 3 experts? How will they add value?
Concerned subjects,
Yes. Lordship is a treating physician plus 2 subject experts plus 2 doctors
not 2, plus 3 experts from the concerned departments.
from the concerned specialty.
Speciality,
Concerned specialty.
that will be very clear.
Yes.
So you'll have elasticity also in that.
Yes.
Then
No, it becomes.
with
it
experience,
becomes
what do you
a-
say about that sentence?
even
Because
number.
we have to make it
No limit to experience.
with experience in critical care and overall standing in medical, at least that will be 15 years. That will remain with experience in critical care. Should that be there?
No,
No, no.
not necessary. Not necessary.
Board has to be a 3-member board. It can't be.
Remember, this is what the board is saying. Some reason which we don't know, some mystical
This
reason.
is at least 3, my lord. So it can be 5, 6, 7.
Normally board is to
We
be.
have said
the-
at least 3. We have said at least 3, which means you can make it a 5.
Oh, no, we want the board to be as small as possible. You don't want it to be expanded.
You want to make it a 1-member board.
No, no, no. I'm not going to extreme. I'm just saying that 1 plus 2, as doctor says, physician plus 2 more people, 3 minds are enough, Lord. Like it's like a 3-member bench.
Is there any reservation of odd number?
I don't know. Treating physician plus 3 members will come. So what will happen is that he will also chip in with, because he anyway is part of the team. He'll say, what is it? And then comes with, we want to know whether we should take out with experience in critical care and overall standing.
Yes, that should go, my lord.
So this with experience in critical care should go.
Go and
that
overall
means,
standing, 20 also should go.
What is your view, doctor?
It should be, there is no need of critical care mentions.
And
Because
20
the person is terminal illness is always critical.
Told not
No, no,
required.
person-
Certified.
the person who is terminal is always critical. His point is well taken. If he
Yes.
is terminally ill, he is already critical.
For that, would a critical care expert would not be necessary.
Not necessary.
Not be required. That is
Doctor knows that he's not going to
not be
survive.
required. There is instruction
As per
from the department. The
what
concerned.
does it say?
Not required that
Do you know that there is a course in, medicine with the critical care? They study critical care.
I have no idea.
They do study.
Yes.
The doctor knows.
Yes.
They specialize in critical care.
ICCU.
Yeah,
I know.
yeah.
But the point is the person is having got 4th stage cancer.
Critical care is a specific term, terminal illness is a generic term. Critical care is included in terminal illness. Everybody who is critical.
So then what should, and then ideally what we should do is this. We should have this treat 3 experts from the concerned specialty, out of which one shall have knowledge of critical care.
Yes, sir.
Then
It will
maybe
become unworkable.
Unworkable. Unworkable. Unworkable. Not
Critical care
possible.
physicians are not there in
Not
many
there.
of the hospitals.
not there.
Many of the hospitals.
But critical care is ICCU. How many wards are ICCUs?
I look at it this way: is a doctor who is involved with critical care may have no time to come to attend a meeting of this kind,
Yes.
because his priority will be the patient that he is undertaking critical care of.
These are the practical imperatives.
No, but
There's a reason.
the place where this patient is taken, if we are talking about withdrawing life support,
So we don't need a critical care expert. Not
presumption is that that hospital is equipped with a life support equipment.
When you talk of critical care, it talks about an ICCU, ICU, advanced.
ICCU?
This is the-
Where else you will find a life
No,
support
no, the
system?
point is who will certify that his life can be taken away?
We are on a different trajectory.
Yes.
See, you are talking about withdrawing life support system.
As per the wish of the patient.
Yes. So the place where the patient is taken, presumably will have a life support system.
Not necessary. He may have 4th stage cancer, he may be brain dead, he may have an
We
accident.
have tried to accommodate so much. Now you come to 198.4.5. You're saying it is deleted. Let's see 198.
Yes, because the point is, because the whole thing, as per the ministry's instructions, there is a primary board, there is a review board. Therefore, we said if there is already a primary board, then the second board doesn't, there cannot be another hospital medical board. And this is the board by the collector. The collector has to constitute a medical board. That's not possible. 198.4.5, where the collector and has to constitute a board consisting of the CDMO and all that. That's not possible.
Counter check. Are you saying, Nataraj, what do you say? They're saying that the second board need not be there.
The collector need not constitute the board.
Who will constitute the board?
No, the collector did not come to the picture.
So that's right, but then should not there be a second board?
Hospital only constitutes a review board.
Review board consisting of which member?
Board is different, but second.
Then we
According to us, review board is not necessary at all.
So.
Yes.
One by one.
No, because the point is one board is enough. But if you want a review board, if a collector is going to constitute it, is an impossibility. We might as well then end of the matter.
Correct. So let's clear what there is. What do you say, Nataraj?
Yes, I'm told instead of the board by the collector, there will be a separate review board that will take care.
A review board means what?
A review board comprising of 3 physicians from the relevant discipline.
From which hospital? From the same hospital?
That's not
If
specific.
available,
Yes.
otherwise.
If available, or else you have to get from outside. That's it.
See, let's see, they look at the, like.
No, we're not.
Not including that treating
Yeah,
doctor,
he-
excluding the treating doctor. He shall not be part of that review board.
Huh?
Treating doctor, he shall not be part of that review board.
That's what.
Second.
Independent team.
And the very same team, if they give a report, what is the?
It is, yes, correct. It must be totally independent.
So that, who will be the doctors of that board? And will it be from the same hospital or from,
So,
From different hospitals,
From-
Lord,
huh?
just from different hospitals, not from the
Exactly.
same hospital.
exactly, that's what you're saying. Therefore, it has to be from a different, it has to be from a different
From
hospital.
different hospitals.
Huh?
From different hospitals.
Exactly,
From the same hospital.
correct.
exactly, that's what you're
But there
saying.
is no need of a review board. There is no need of a review board. Once there is no substitute for trust. The receiver
Not in this matter.
dealing between doctor and patient.
Then we
is
will
based
be
on
completely
fiduciary.
knocking out the basis of the judgment.
That's a technical point, but as a doctor, no, became that there is no substitute for fiduciarism. Trust. People have handed over body to me and I have used knives on their bodies. So there is no documentation. It's a trust. So if a doctor says that the patient is terminally ill and there are no chances for him.
One thing, subject to what is compound. Since we want to consolidate first board and the review board as one board, let us have a broad-based board so that it may take care of
Good point.
all nature of casualties or one board,
Yes.
broad-based, so that they may take decision one for all.
Or let be a 5-member board in the beginning.
Yes,
All such decisions may go to that board. All such decisions may go to the board.
five members board, but one board.
Two members of this board is not, are not.
This is what they are doing this is what they are doing in Netherlands. In Netherlands, they have made a broad board. Every case of withdrawal of treatment goes to that board for review.
If this kind of a system will go on,
It's fine.
by the time the board will take a final call, the man is over.
We can fix the time limit.
Man is over.
No, we may fix the time limit, but the doctor has to come. If he's not going to come, what is going to be contempt? We don't know.
No.
Suppose there's no time limit, what do you do?
That will be the patient's heading.
And you,
Patient will take it.
but the point is, if we have to sort of
My
balance.
lord, brothers may not be, we may not be, there might not be unanimity in these matters, so that we can't be.
No, but my only submission is, if you want a primary, two options are, we are agreed that there's a primary board. We're also agreed that the primary board consists of treating physician plus 3 experts. That's closed. Now, question is, have a review board. Now, one option is to have a review board of doctors of another hospital consisting of, let's say, 3 people. Or you can give opinion for one leading doctor from that or another specialist from that doctor to confirm. It cannot be another team of 3 doctors. The decision taken by one team of 4 doctors is presented to another doctor of the same specialty for an opinion. Now we're looking at a person who has got cancer. Now I'm not able to visualize how many doctors you require to say that this man is going to die in 3 months. If 4 doctors say that this man has got 4th stage cancer spread all over his body, just visualizing situation. Now,
No,
do we require
every situation may not be of
I'm giving example.
this nature.
No, I'm just giving example. So we are still having a review board. Now, if the review board is going to consist of 4 more people, it is going to become more cumbersome.
Yes,
If you want to have it that way, it is that way.
You never
Otherwise, we
know
just have
whether
it.
somebody has gone into coma in stroke. You never know whether it will come back in 7 days.
That's gone. No,
may
that is
not.
gone. That permanent vegetative is deleted. That coma thing is deleted. That's permanent vegetative is gone. Only terminally ill. There's no coma.
In these kind of matters, without review board, I don't think nobody can take.
So have a review board, should have a review board with doctors from another hospital. That's all. 3 doctors from another hospital.
From another hospital.
That's all.
Now what is the position? Now the collector.
Now the collector has to constitute a board.
CMO.
The TMO, then 2 more doctors, then they will go, then that will be given to the judicial magistrate. Then he will agree whether that 3rd member team is correct or not.
The only thing,
You see, one thing is there, you will have a CMO all over India. In every government hospitals, one thing is common, whether it is in Assam, my brother's state, or whether it is Bombay or whether it's Chennai.
My request
We'll
is,
have a CMO.
my request is please
So
do
that is why, and why perhaps this court thought was, you will have a counter check from an official machinery. That is what this court had in
But
mind.
then again, they're all
What
lacking
is-
trust.
we want to know.
You're lacking trust in the doctors. That's what that's what they feel. You're not trusting us.
That's right, it's not a question of just.
No, it is, no, you have to respect of
You
your
have
particular
to-
medical profession also.
That's right.
Why should the collector
Now
come into
what-
the picture?
Now what is the position? Chief medical officer and two others.
Where,
Yes,
If they,
that's the
if
second.
the review,
Yes. yes.
Then
what is contemplated, let us see,
Yeah.
collector must beforehand.
Yes, Your Lordship, the chief medical officer has, the collector will constitute a board that comprises the chief medical officer and 3 other experts.
Yeah, right.
And they will provide an opinion, and then after that, the JF, the judicial magistrate has to come to hospital and decide whether or not treatment can be withdrawn. Now, that,
No, that the JFM, after supposing the original board is endorsed by the review board,
even
then perhaps we can say that we can go on. There is no question of, again,
That's enough.
that should be
But
enough.
now the hurdle is what is the review board? Manoj? Hurdle
That's
is the
what-
review board. Now, whether the review board should be done by the collector or should be done by the hospital can say, all right, X hospital may say, please get three doctors. Hospital says we'll request 3 doctors from the neighboring hospital nearby to come and confirm our view. There's a review board, their decision is recorded, it's in writing. That's all.
So in the sort of, length and breadth of the country with all the, variations that you find. Them everywhere. Whereas if you say that it's a private hospital, they may not have the experts which you're talking. We started that with, that is the starting point.
Take a last town, let's say, forget Madras, Bombay,
We
take
can put a
Coimbatore.
time, we can put a time.
No, take Coimbatore, the chief medical officer, he has to constitute a board. And how does he have a,
What do you mean by chief medical officer, first of all? What do you mean by, it's a government
Or-
hospital?
or one thing is there,
Ah,
every government hospital will have a team of 3 doctors,
Right.
consisting of CMO plus 2 persons, who will certify the decision of the private hospital, that's all. That can be a review board.
personally, I have no problem with it, but it should be, what is the stand of the government of India? Because they are the persons who would be.
Everyone is not there.
But can we then discuss the review board tomorrow? We'll discuss that amongst ourselves and come back.
You don't want us to dictate today.
No, but we cannot be fight. At least review board will sort out some issue.
We thought we could have closed it anyway if you don't want it to.
No, I don't, I.
The arbitration case tomorrow, we thought that should end today. What do you say about that review medical board? What-
Yes, the review board,
Or you want to get back to us tomorrow?
I'll get back
And then
tomorrow.
let's-
I'll get back tomorrow for 10
close it
minutes.
tomorrow.
Yes, I'll get.
So we'll also have a better,
Who will constitute the board by CMO,
Yes,
collector?
DMO is.
have a better.
DMO.
DMO is better because he's in the field. Collector is an executive who will be having a lot of us.
CMO or any person authorized by him,
That's right. That can be.
because you have an additional chief medical officer.
That's right.
Like
The
two boards.
collector will be having a lot of other
The
responsibilities.
collector is constituting a board,
Yeah.
a new board. Then what the CMO will do?
Yeah, this is the.
Board is constituted by somebody else. Then you need a person of government officials. If the review board is by the collector himself,
Yes.
by the DM,
Yes.
or the collector you call it. Then why is CMO required?
No,
That's not
The
it.
collector forms a board consisting of the CMO.
That's why I think if collector is forming the board, then CMO has no role because he doesn't know anything.
No, CMO will be the review head.
That's correct. He know otherwise nothing.
He'll not.
Is any reason given in the judgment
CMOs are made.
as to why this
Who is the CMO?
review board
CMOs are made.
medical officer
Any,
no, Your Lordship.
I don't think there is a much deliberation.
without any specialist qualifications. If he completes particular years of subject by promotion, he is made the chief medical officer.
That's all.
So his knowledge,
His medical knowledge is thin.
He may not have.
he may not have any specialized knowledge.
Not medical knowledge, no medical knowledge.
No, he have. He may not be an oncologist. He may not be.
Even MBBS.
He
Even
may,
MBBS.
No, I was thinking, Mr. Lordship is retiring for the day.
it's according to
One
seniority.
sec. The review board can be consisting of 3 experts.
Practical reality, somebody who has passed MBBS, he will know who is a terminal patient.
Yes, exactly. Then why
have
make
agreed
this
with you?
experience?
If we were hearing originally, we would have agreed with you, but
No, no,
what
no.
can we do?
But the point is,
There's a point beyond which you can't.
no, but the point is, we are not into review reviews. We're just trying to make the directions workable.
That's right.
That's the, Lordship knows Lordship can always recall the judgment.
Rajan, you also take it. If the collector is constituting a review board with experts of a nearby hospital or somewhere else,
Yes.
and subject to your
Yes.
instruction, so CMO is not going to work. Because CMO, by that time, most of the time, he's not at the place where he's supposed to.
Correct. No, first of all,
There's also one more idea.
first of all, this responsibility should not be given to the collector at all. He's an executive person, he'll be having a lot of other works, not to constitute his
He
board
is
and all those.
constituting the
Yeah.
board. He constitutes
That
the
that can be given to district medical officer, who will be more conversant with this, the ailment and all
I
that.
I
He'll be
got
able
one
to
more
take it.
suggestion. It's a review board. Now, if it's a review board, now if one team has taken and filed a report, I don't know if the review board should personally come and inspect the patient. If the records can be sent to the review board and the records show that this person is terminally, that should be enough.
Would decide that.
That will be we can't take.
No, that's not.
Today we elaborated the procedure, that, I mean, that, we are not going to change that. So, I mean, it obviously is drawn from another hospital. The members will be drawn from another, need
No,
not
I'm
be from the
saying
government.
the question of the review board revisiting the hospital, I'm just putting, please think about it.
Revisiting.
No, he says that the entire team must come back to the hospital, check the patient again, then file a report, then that should go to
They
judicial
will
magistrate.
necessarily have to do that. What,
No,
how will they know?
I'm just suggesting
Yeah.
that
No,
suppose
we can't.
there is a report by X hospital that Mr. X has got advanced cancer. These are his X-ray, these are his medical report, this is his MRI, whatever it is. If that is sent to the review board
No, no,
and the review board can see the document and say, yes,
no, no.
it is a case, that's enough.
This is not, this is not a.
It should not be, because we will tell you.
He has to come
Very
back.
clearly it is stated, who will,
That's
they
not-
shall jointly visit the hospital.
I'm
where
saying
the
that's not
patient is admitted.
necessary.
And if they concur with the initial decision of the medical board of the hospital, they may endorse the certificate. This is a procedure which has
Correct.
been laid out with, after reserving the matter with great care, they have laid it out.
Yes.
We are wanting in one moment.
Yeah,
we are
leave the
trying to
lordship.
talk
Can't do it. Not criminal appeal there.
Only point is, the medical officer, instead of the collector, we can knock out the collector there.
Yeah.
The chief medical officer, upon being notified,
Correct.
he will constitute a mode.
Yeah.
This is what we can bring.
Yeah.
And what is the remaining portion? Anything else is there? 198.5.1, which you have. You are trying to change, a case of refusal which is to be challenged in a restitution, you want it to be referred to a medical board. Let's see, 198 point, at page, is only what last for me.
No, we have not deleted the High Court.
Close.
No, my lord, what happened was, we did not delete the High Court part of it since the lordship said you're not sitting in.
Then
review.
again, red is coming again.
Yes.
No, what is this last red?
No, now
There are several, brother.
there's some more reds there.
There are several, not just last.
So are you flushing out the other reds?
We'll show it to lordship. It'll take half an hour to say what it is.
So we'll also go through it. Today
That's
you're
why I'm-
doing it. So we might get a better idea. Then come tomorrow, what else can we?
Brother, one last word. if I may. Actually, Mr. Dartar had mentioned about Justice D.A. Desai saying God is above us.
Only God is above.
Only God is above. Brother Ravi Kumar talked about the orphan. And Justice Joseph talked about the unmarried orphan. So then you have close relatives and responsible person, and then third / Ram Bharose.
My understanding,
Yes, thank you, lordship's time. Your lordship is really taking so much of.
Eh?
Thank you, lordship's time.
at
Lord.
best
Almost
of time, the distrust has so developed, we are not trusting the system going on.
That is the main anguish of the doctors. Lord.
We have to trust them.
The main anguish of the doctors is this kind of multiple thing again and again and again, as if they're just going to pull the plug for anybody.
There is one principle of logic. One principle of logic which we are actually missing out. You see, if they want if the doctor certified that the treatment should be cut off, actually it's not in their financial interest.
Yes.
That's right.
So ordinarily, when they certify, Yes, that he has reached that stage, please cut it off. Yes. It'll go against hospital because hospital will stop earning money. Still, if when the board says, yes, he says that it's condition, please cut it off. That normally the insurance ground should be under 140, 114. That's, they're acting bona fide.
Yeah.
Yes.
They would not do it normally.
Presumption now, 114 presumption.
You are in our profession, the best relief is the remand, it seems. That's what it is said.
Huh?
The best relief party gets is, so far as lawyer is concerned, it's the remand order. That's what it is said.
So you go back.
Come on.
Tomorrow when? Tomorrow when?
Tomorrow when? So can we do one thing? Let us complete the arbitration matter in the forenoon session. We'll keep this at 2 o'clock. So that
Keep this at 2 o'clock.
after the arbitration,
Keep this at 2
you
o'clock.
can come at 2. You're free to come for the arbitration also. That's a different matter.
No, no.
Yes.
Okay.